This hearing will come to order. Today we will discuss H.R. 1633, the Farm Dust Regulation Prevention Act of 2011. In most respects, this hearing will be similar to many of the others our subcommittee has held this year. As you know, we have jurisdiction over EPA's Clean Air Act regulations, and we have an obligation to the American people to ensure that new regulations do not impose burdensome costs or obstruct job creation, particularly at a time when our unemployment is high, our economy is struggling, and uncertainty is widespread. EPA's unprecedented wave of stringent and inflexible regulations pose a serious threat to the economy on job creation, in our opinion, which is why we have held an unprecedented number of hearings to the plethora of regulations issued by EPA. The only difference between today's hearings and most of the others is the target of the EPA regulation issue. Many of the previous hearings dealt with rules most directly impacting manufacturing and energy production. Today we discuss EPA's particulate matter standards and their potential impact on family farms and small businesses in rural America. EPA is in the process of revising its national ambient air quality standards for particulate matter. This includes PM10, which is coarse particulate matter, also known as dust. Although EPA has said it will not propose changes to its existing dust standard, there are several reasons for uncertainty about the outcome of EPA's ongoing review. EPA has discussed further regulation of farm dust since 1996. Most of us do not believe that the current standard, the PM10 standard of 150 micrograms per cubic meter, we believe is sufficient and should not be changed, especially given the absence of evidence that farm dust poses a health threat. In April 2011, EPA issued a policy assessment that recommends the standard either be unchanged or lowered to 65 to 85 micrograms per cubic meter. The assessment also recommends a change in the way compliance is measured. Any changes to the current standard would almost certainly force states and localities to impose additional restraints on farming and other operations in rural America in order to comply. It is possible that EPA will ultimately retain the current PM10 standard in its pending review, but it should be noted that the last time EPA considered revising its standard for PM10 in 2006, the final version did not adopt an exemption for agricultural dust that had been on the table at an earlier stage. At this time, I would like to recognize the gentleman from Kansas, Mr. Pompeo, who is the sponsor, I believe, of this legislation, for 1 minute.
Thank you, Mr. Chairman. Thanks for holding this hearing on H.R. 1633. You know, I represent a agricultural state, and my district has lots of production agriculture. It's part of who we are. The issues that these folks face are like a lot of other small businesses, crushing regulations and tax burdens. But some have a very different flavor, like this one. The issue we're talking about today, the effort to regulate farm dust as a particulate pollutant, is one of the most concerning and potentially most burdensome regulations coming from Washington, D.C. in my 10 months here so far. Now, the EPA's recent announcement that it currently has no intention of imposing new regulations on dust sounds to me like a purely political and likely temporary decision, and frankly doesn't give our farmers in Kansas or across the country the certainty they need. The fact remains that EPA staff has suggested tightening this regulation, and that tightening of the regulation would include farm dust. Look, like many other sectors in our economy, we need long-term planning. We need the ability for farmers to know what they can and can't do. That's why I'm proud to be a co-sponsor of the Farm Dust Regulation Prevention Act, and I'm pleased to have Congresswoman Noem and Congressman Hurt here this morning to testify about it. Thank you both for being here. With that, I yield back my time.
Thank you very much, and I'll yield back the balance of my time as well, and I recognize Mr. Rush for 5 minutes opening statement.
I want to thank you, Mr. Chairman, and I also want to thank all the distinguished witnesses who will be here at today's hearing and testifying. Mr. Chairman, we're here to discuss the Farm Dust Regulation Prevention Act of 2011, even though last week EPA made the decision that it would not propose any changes to the current standard of 10 ppm or 10 micrometers for coarse particulate matter. The basis of today's hearing is H.R. 1633, the bill introduced by Representative Kristi Noem of South Dakota, who we are pleased to welcome to the subcommittee for her testimony today. H.R. 1633 would bar EPA from revising its rules for coarse particulates for 1 year and would also create a permanent exemption for, quote, nuisance and, quote, dust from farms and country roads. I look forward to hearing from Assistant Administrator of the Office of Air and Radiation, Gina McCarthy, as well as other stakeholders testifying to better understand the impact that this proposed legislation will have on the Clean Air Act, as well as on public health. In particular, I have concerns over Section 3 of H.R. 1633, which states that the Clean Air Act does not apply to, quote, nuisance and, quote, dust, and will eliminate EPA's authority under the Clean Air Act to regulate anything that constitutes nuisance dust, except in narrowly defined circumstances. As currently drafted, nuisance dust is defined as particulate matter, that is, one generated from natural sources, unpaved roads, agricultural activities, earth moving, or other activities typically conducted in rural areas, or two, consistently primarily of soil, other natural or biological materials, or wind-blown dust. However, the phrase other activities typically conducted in rural areas is much too broad and could potentially include a host of industrial activities that are commonly located outside of urban areas that will be exempt from clean air regulations, including power plants, ethanol refineries, mines and smelters, and pulp and paper mills. Section 3 raises serious concerns over whether EPA could continue to implement the existing fine and coarse particle pollution programs, or whether the EPA could ever adopt or implement revised fine or coarse particle standards. However, H.R. 1633 takes certain types of particulate matter out of the entire Clean Air Act altogether. This bill could potentially forever prohibit EPA from regulating mercury from coal-fired power plants based on the argument that mercury is emitted as particulate matter from coal-fired power plants, and burning coal to generate electricity is an activity typically occurring in rural areas. Additionally, as written, Section 3 is not limited to stationary sources, so H.R. 1633 calls into question EPA's ability to set tailpipe emission standards for new vehicles or engines to limit their fine particulate pollution, as well as its ability to enforce existing particulate standards for new vehicles or engines. So I think it's important, Mr. Chairman, to clarify the bill's language to avoid unintended consequences to the overall Clean Air Act. Mr. Chairman, I look forward to hearing from all of the panelists on the merits and necessity of H.R. 1633, and with that, I yield back the balance of my time.
Thank you, Mr. Rush. At this time, I recognize the full committee chairman, Mr. Upton of Michigan, for 5 minutes.
Well, thank you, Mr. Chairman. Today's hearing looks at a source of major concern to the ag sector in rural America, which is EPA's regulation of coarse particulate matter, otherwise known as dust. H.R. 1633, the Farm Dust Regulation Prevention Act of 2011, provides relief from this regulatory threat, and I welcome two of the co-sponsors of this bipartisan legislation, Kristi Noem of South Dakota and Robert Hurt of Virginia, who are here today. The very last thing that our struggling economy needs is new costs and regulatory burdens on farmers and small businesses across rural America. They already face indirect consequences from EPA's costly regulatory agenda, and now they are rightfully concerned about the threat of direct regulation of their options. The EPA recently announced that it plans to propose retaining the existing standard for coarse particulate matter, and I appreciate those assurances. But like the stakeholders that we'll hear from today, I'm not at all satisfied with the step for the simple reason that regulatory uncertainty will remain. EPA's proposal could change throughout the review process. The ag community's concerns may not be fully addressed, and even if the final standard contains no changes, it is always subject to court challenge. For those reasons, EPA's insistence that it does not plan to change the rule is far from a guarantee that such a change would never come to pass. In the face of this ongoing regulatory uncertainty, this legislation makes good sense. The bill is targeted. It prevents EPA from setting a new coarse particulate matter standard for 1 year. It also makes clear that state, tribal, and local governments have the authority to regulate so-called nuisance dust across rural America. The state and local emphasis is appropriate for dust, which is a local issue. The bill gives EPA authority to regulate nuisance dust in the absence of state or local action and after both costs and benefits are taken into account. That's common sense, and it protects the interests of our vital rural economy. I commend our colleagues for putting together their legislation on the table. If EPA is serious that it does not intend to regulate farm dust, it should embrace this legislation. I yield to the gentleman from Texas, Mr. Bart.
Okay. Did Mr. Shimkus? Okay. Well, first of all, thank Congresswoman Noem and Congressman Hurt for introducing this and being here. We're beginning to have some dust storms like we had back in the 1930s. We had a very bad one in Lubbock, Texas last week. There are differences of opinion as the cause of the storms, but it appears that we're in a cycle where the weather conditions are such that we're going to have drier weather and a little bit warmer temperatures, and so we're going to have dust storms. EPA back in 2006 suggested that we shouldn't regulate farm dust. I wish the EPA would dust that proposal off and institute it instead of even thinking about regulating farm dust. As the chairman just said, this legislation is preemptive in nature, and I would hope that we can move it very expeditiously. We don't want to have a recreation of the 1930s, and because of farm practices and some of the dam projects that have been constructed, we shouldn't, but we also don't want to overreact and regulate something that God himself or herself can't regulate. So with that, I would yield the balance of the time to Mr. Olson of Texas.
I thank my colleague from Texas. Mr. Chairman, I thank you for holding this hearing on H.R. 1633, the Farm Dust Regulation Prevention Act, of which I'm a proud co-sponsor. This hearing is critically important in my home state of Texas. Texas has been battling an unprecedented drought. In my hometown of Sugar Land, we're almost 2 feet behind our annual rainfall. In addition, wildfires have burned 3.6 million Texas acres. Texas farmers and ranchers have been hit particularly hard by the drought and the fire. And to think that the EPA is attempting to regulate farm dust now or in the future is simply out of touch with reality. This move would impose devastating, unjustified, and burdensome regulations on farmers and ranchers already struggling in this economy to provide food for an ever-growing population. Mr. Chairman, as you know, farmers and ranchers are the backbone of America. We must give them the tools and certainty plan for the future so they can succeed. I welcome all of our witnesses here today, particularly my colleagues from South Dakota and Virginia. Look forward to your testimony. I yield back.
Thank you very much. At this time, I recognize the ranking member of the full committee, Mr. Waxman of California, for 5 minutes.
Thank you very much, Mr. Chairman. Today's hearing considers yet another bill to allow more air pollution, more asthma, and more heart attacks. And once again, it's a bait and switch. The bill's sponsors say the legislation is narrowly targeted to help farmers. In fact, the bill is drafted broadly and has sweeping anti-environmental effects. We're going to hear today that we must pass this bill to stop EPA from regulating farming. This isn't just nonsense, it's pure fantasy. EPA does not regulate farming practices to reduce dust and has expressed no intention of doing so in the future. EPA has set standards for the levels of coarse particulate matter in the ambient air because there is scientific evidence that this pollution causes serious health effects. Coarse particulate matter, or PM10, is produced by uncontrolled burning of coal and oil, construction and demolition activities, mining and unpaved roads, as well as farm activities. Once EPA sets the standards for ambient levels of air pollution, it's up to the states and localities to determine how to meet them. It is the states and the localities, not EPA, that decides which sources must reduce pollution and by how much. EPA set the current PM10 standards in 1987 during the Reagan administration. As required by the Clean Air Act, EPA has recently reviewed the science supporting those standards. And based on that review, the administrator recently announced that she intends to propose making no change to the Reagan-era PM10 standards. Now we're being told that we need to pass this bill because EPA could change its mind and do something the agency said it has no intention of doing. If we adopt this standard for legislation, there's no end to the bad ideas we could legislate. Should we pass a law saying the United States cannot invade Canada, or one preventing the government from outlawing apple pie? We are facing real and serious problems in this country that are happening right now. Millions of Americans are out of work. Our economy is stalling. Fires, floods, and droughts are afflicting our nation. We need to spend our time addressing these real challenges, not squandering it on imaginary problems. But even though this bill stops something that won't happen anyway, that doesn't mean the bill has no effect. H.R. 1633 is so broadly worded, it could invalidate EPA's existing standards for both fine and coarse particulates. This would have a devastating effect on clean air requirements and public health. The biggest problem is in Section 3, which is not limited to farm activities, rural areas, ambient air quality standards, or coarse particulate matter. It says the Clean Air Act does not apply to anything that meets the bill's definition of, quote, nuisance dust, end quote, unless a narrow exception applies. And the definition of nuisance dust is sweeping. It includes, quote, windblown dust, end quote, which is undefined and not limited to rural areas. And it includes any particulate matter, quote, generated from activities typically conducted in rural areas, end quote. Well, mining is typically conducted in rural areas, and mining operations have huge equipment that can generate large quantities of particulate air pollution. 70% of the nation's power plants are located in rural areas. The particulate matter generated by power plants includes not only fine and coarse particulate matter, but also particles of mercury and lead and acid particles that form from nitrogen oxides and sulfur dioxides. Children in rural areas typically take the bus to school, and diesel buses generate particulate pollution. Under this bill, EPA could have no authority to regulate any of this pollution. Now, the bill's sponsors will argue that they don't intend to exempt mines, power plants, or school buses from regulation under the Clean Air Act. But as we've seen from so many other bills this Congress, the bill language doesn't match the stated intent. It's the legislative language that matters, and the language could result in a massive increase in dangerous air pollution. This year, this subcommittee has reported bills to allow more carbon pollution, more air pollution from offshore drilling, more air pollution from power plants, more air pollution from industrial boilers and incinerators, and more air pollution from cement kilns. Today's bill is more of the same. Americans want their kids to breathe clean and healthy air, not another bill to let polluters off the hook. Thank you, Mr. Chairman. Yield back my time.
Thank you. And at this time, I would like to recognize our members on the first panel, Congresswoman Kristi Noem from South Dakota and Congressman Mr. Robert Hurt of Virginia, the primary sponsors of this legislation, and we genuinely appreciate your being here with us today. And I'll recognize each of you for 5 minutes for your opening statement, and Congresswoman Noem, will begin with you.
Sounds great. Thank you, Mr. Chairman, and the ranking member who's not with us right now. But the rest of the committee members, I appreciate you for having this hearing today and for letting us bring forward the H.R. 1633, the Farm Dust Regulation Prevention Act of 2011. I introduced this common sense bill on April 15th of this year with my colleagues, Representative Robert Hurt, Larry Kizel, and Leonard Boswell, because of the regulatory uncertainty that's facing rural America. We certainly have challenges in front of us. My bill is a bipartisan approach to ending the EPA's regulation of farm dust in rural America while still maintaining the protections of the Clean Air Act to the public's health and welfare. It's not a Republican and it's not a Democrat issue. There's broad bipartisan support with over 100 colleagues on both sides of the aisle sponsoring this bill. And the committee will see in the record that there's also over 100 agriculture and resource-based organizations who have written in support of the bill as well. As this committee knows, there's growing concern that excess regulations are hampering economic growth and job creation across the country. In my home state of South Dakota, there's a huge concern for farmers and for ranchers and small business owners who are struggling to stay afloat in an already stressed economy. One of the most overwhelming concerns that I hear from farmers every day and ranchers back home is the overbearing regulations coming out of the EPA, including the regulation of farm dust. Their concern is certainly not unwarranted. Under the Clean Air Act, the EPA is responsible for setting the national ambient air quality standards for certain pollutants. This includes particulate matter, which is broken down into fine and coarse particulate matter, commonly known as dust. The administrator of the EPA, Lisa Jackson, must set the national ambient air quality standards that states must be designated either as in non-attainment areas. The goal of these standards is to protect the public from harmful pollutants like industrial soot, car emissions common in urban areas, which I certainly support. The EPA measures the amount of particulate matter or dust in the air through monitoring devices that are placed throughout the country. At least every 5 years, the administrator must review those standards, decide if they want to keep the current standard or potentially adopt a more stringent standard. As this committee is aware, the EPA is currently in the process and in the midst of another review. Under current law, the EPA standards include all kinds of dust, including dust generated from ag activities and the dust that's typical in rural America. This type of dust is naturally occurring and includes soil, wind-blown dust, or dust that comes off of dirt roads. I call it farm dust. This is completely different than the type of dust typical in urban areas, which has been shown to have adverse health effects. My legislation specifically focuses on rural dust. It allows the standard to apply unchanged in urban areas. Farm dust is a fact of life in rural America, and unlike urban dust, has not been shown to have a significant health concern. Including farm dust in the National Ambient Air Quality Standard regulations causes great concern and uncertainty for farmers and other resource-based industries in rural America. I'd like to clear up the myth that the EPA does currently not regulate dust. Farmers and ranchers are already subject to the standard for dust in non-attainment areas like Arizona. There are people in Arizona that certainly know the impact that this has on businesses. It can cost some producers in that state over $1,000 a day to comply with dust standards. On September 17, 2011, a Des Moines Register story tells the story of Kevin Rogers, who's going to testify here later today and tell his personal story. He's a farmer from outside of Phoenix, Arizona, that if the wind is blowing too much, he has to park his tractors. He has to park his combines so that he doesn't kick up too much dust. As a lifelong farmer and rancher myself, I certainly understand the impact that this can have when you have a job to get done and you have a business to run. And as Kevin puts it, it's a difficult thing when the government is in the middle of every single thing that we're doing. We need to put an end to regulation of farm dust and prevent its expansion into the future. Regulation of farm dust is a problem today and will be more of an issue if the EPA continues to have opportunities to make more stringent standards into the future. The inclusion of farm dust in the EPA's national ambient air quality standards will continue to be a problem until legislation is enacted to ensure that farm dust is treated differently. EPA is well aware that it cannot, under current law, differentiate between dust coming from rural areas or urban areas. And while officials in the EPA continue to say that they have no intention of regulating farm dust, the EPA does regulate farm dust and has no plan to exempt naturally occurring farm dust from their regulations. This bill certainly provides a solution. It gives us the ability to differentiate between natural occurring rural dust and that is typically occurring in urban areas. And also, what it does is it provides immediate relief for farmers in rural areas by preventing any changes to the current standards for 1 year. Secondly, it provides flexibility for states, localities, and tribes to regulate farm dust and nuisance dust themselves. I certainly appreciate the opportunity to testify before you today, and I'll certainly stick around and answer any questions that the committee may have for me.
Thank you very much. And Mr. Hurt, you're recognized for 5 minutes.
Thank you, Mr. Chairman. It's an honor to be with you, and I thank you for the invitation to be here to talk about H.R. 1633. It's an honor to be here with Representative Noem, and I appreciate her leadership on this as well. I represent Virginia's 5th District, a primarily rural area which includes most of central and south side Virginia and is larger than the state of New Jersey. In the 5th District, we have a proud heritage in agriculture, manufacturing, and other resource-based industries that provide good-paying jobs for thousands of Virginians. Dust is a necessary byproduct of the hard work the farmers and businesses in my rural district perform every day. These are the people who are struggling to survive, to grow, and to create jobs during the stalled economic recovery. That is why the EPA's National Standard for Fugitive Dust, which falls under the Clean Air Act's National Ambient Air Quality Standards for coarse particulate matter, is so troubling to the people that I represent. It is yet another example of the expansion of federal government and the uncertainty that Washington continues to impose upon our family farms, our small businesses, and our rural communities. That is why H.R. 1633 is necessary. The bipartisan legislation will help create a better economic environment for job creation by replacing the current federal standard for dust that comes from driving on unpaved roads, working in agricultural fields, and similar activities in rural America. H.R. 1633 provides relief from the more stringent federal standard for coarse particulate matter recommended in the April 2011 policy assessment prepared by the EPA staff. It also gives states and localities the flexibility to set a standard for dust if they choose. More important, it keeps the federal government out of the business of overregulating naturally occurring dust unless the EPA can prove substantial adverse public health effects caused by dust and can provide a rigorous cost-benefit analysis on the need for such regulation. While I applaud EPA Administrator Lisa Jackson's recent promise that she will not propose a more stringent standard for coarse particulate matter, I remain concerned about the uncertainty of the rulemaking process where these rules can be modified. I'm also troubled by the comments of some of the administration officials to discredit the issue of federal dust regulation, including the Secretary of Agriculture, Tom Vilsack, who wrote that the regulation, and this is in quotes, the regulation of farm dust is another frequently repeated myth. After reviewing the EPA's 2006 federal standards for coarse particulate matter, which by definition includes dust, I respectfully disagree with the statement that this is a myth. I know that farmers and business owners in the 5th District disagree with this assessment of dust regulation as well. When traveling in the 5th District last year, I spoke with a small business owner who was warned by a state regulator about the amount of dust that was coming off of his property. When the business owner questioned further about the regulator's concern over this dust, the regulator replied that the business needed to take active measures to decrease the dust coming from the dirt driveway leading in and out of his facility. It also appears that the Sierra Club would take issue with the administration's statements that federal dust regulations are a myth as well. When discussing a petition it filed with the Virginia Air Pollution Control Board in my home state, which was ultimately dismissed, by the way, the Sierra Club alleged that the levels of dust it measured on a road in southwest Virginia were above the national health-based standard promulgated by the EPA. It's difficult to understand why the Sierra Club would take such action if the federal government mandates for fugitive dust are a myth. While it is true that the EPA and state regulatory agencies have not set up monitors at every family farm and every unpaved road, the Sierra Club has shown one way in which these national standards for dust regulation continue to provide uncertainty for rural America. Because of these dust regulations, rural farming and business operations can face the threat of unnecessary harassment, regulation, and litigation by private actors or state and federal regulators. Additionally, companies throughout the 5th District and the country are required to comply with the federal standard for dust in order to obtain permits such as those issued by the Virginia Department of Environmental Equality as required by its state implementation plan with the EPA. This is why Congress must act in a bipartisan fashion to pass H.R. 1633 and assure our farmers and our rural industries that naturally occurring dust will not be the subject of expanded federal regulation. When it comes to dust, the EPA and the federal government should not mandate a one-size-fits-all standard that could eventually lead to lost production. With unemployment rates nearing 20% in some areas of Virginia's 5th District, we simply cannot afford to continue to perpetuate unnecessary regulations and uncertainty for the farmers and businesses in our rural communities. I thank the chairman and I thank the ranking member for inviting us to appear. I thank the subcommittee for considering our bill. I appreciate the opportunity to testify this morning and look forward to any questions.
Well, thank both of you for your testimony. We appreciate your taking time to talk about your legislation, and I was delighted to hear Ms. Noem indicate that you do have bipartisan support. How many co-sponsors are of this bill do you have?
Well, there's 100 co-sponsors that are signed on to the bill. There also has been a lot of support shown over in the Senate side as well. I mean, it's a common sense bill that we certainly recognize could be addressed, the concerns could be addressed through this legislation.
And has a similar bill been introduced on the Senate side?
You know, there has been a bill that has been talked about. I'm not certain if the sponsors are continuing to pursue it.
Yeah. But when we say that EPA is not regulating coarse particulate matter. Of course, in any non-attainment area, if the state does not have a state implementation plan, the federal government certainly has the authority to step in. Is that correct, Mr. Hurd?
Absolutely, and I would like to maybe address some of the concerns that were raised by Mr. Rush and Mr. Waxman. That Section 3 it does allow for the federal government to come in, but under circumstances that I think any American would find very reasonable, and that is when it is proven that there are substantial health risks and that after a cost-benefit analysis that this makes sense. And I think that from what I have heard across my district, that's exactly the kind of view that Americans and 5th District Virginians would like to see going on here in Washington. And it's also important to note that this does nothing to change the particulate matter 10 and PM 2.5 standards. Right. The emissions that the ranking member and Mr. Waxman discussed would still be regulated under or viewed through those different standards.
You know, it is interesting. We find ourselves here discussing the regulation of dust. I know that there are some studies that say, well, there's some correlation between particulate matter, coarse particulate matter, and health, and then there are other studies that indicate there is no causal relationship whatsoever. And yet, and I know we have a gentleman from Arizona, I believe, in the next panel, but it's my understanding that under the state implementation plan of Arizona, in some instances on windy days, farmers are literally prevented from farming. Is that your understanding, or?
Mr. Chairman? Yes, it is my understanding, and that would be the facts that they face every single day. And I think there's a clear definition and difference between urban dust, which is the kind of dust that has been proven scientifically to create the adverse health effects that a lot of the questioning has come from. There hasn't been that kind of scientific research and data that has shown the detrimental effects of this nuisance dust, which we're addressing in this piece of legislation. We're talking about dirt, soil, matter that occurs naturally through the course. So some of the concerns that were brought up in previous statements did happen to come from coal-fired plants, from mining, other situations such as that. Scientific research has proven that that's very different than the type of rural dust that we're talking about with this piece of legislation.
Yeah.
If I could just comment on that, I think also one of the things that I've discovered in working on this legislation is that at some level we have standards, but at some level, at the end of the day, if you can't abate the dust, the only way to stop it is to stop production or stop driving on the roads.
Right.
And what does that translate to?
Right.
It translates to lost jobs.
Yeah. Well, one thing that I think also is beneficial in your legislation, my understanding under the Clean Air Act, there really is no definition of nuisance air, so it could be whatever it could be. At least in this legislation, you make an attempt to define it, which may not suit everyone, but that would be an area that we would have an opportunity to work with others to at least have a definition of that, which I think is important.
Yeah, Mr. Chairman, I would agree. I think this piece of legislation, the EPA should have no problem with. I really do. I think they should be very supportive of this because it simply says that they're not going to change their standards for a year, which they've already said that they're not going to do. And then it provides that definition. Rural dust and urban dust is not the same thing. And I think it'd be very helpful to them in their processes and how they evaluate the ways that they approach enforcing the Clean Air Act to have that definition in place because they're very different, and the research behind them shows that.
Well, some people make the argument, well, EPA is not going to regulate it anyway, so we don't need this legislation. But we know for a fact that entities file a lot of lawsuits over at EPA, and whether EPA intends to do something or not, they frequently find themselves in lawsuits, and frequently they enter into consent decrees, in many instances agreeing with the plaintiff, and then it becomes a court order, and that's another frustrating thing. We find the court involved in as many of our environmental regulations, their decisions, as we do regulations coming out of and initiated by EPA.
Mm-hmm. Yeah, Mr. Chairman, this bill provides certainty, and it provides certainty to a risky business that a lot of farmers and ranchers engage in, and the people in rural areas are trying to keep their doors open and provide for their families. Right. And this shows them that we're going to give them the certainty they need to be protected from those types of sudden regulations that may come up because of lawsuits and environmental issues.
Well, thank you all very much. At this time, I recognize Mr. Rush for 5 minutes.
Well, thank you, Mr. Chairman, and I want to also thank my colleagues, Representative Noem and Representative Hurt, for being here today, and I want you to know that my grandfather was a farmer. I was raised in my early years on the farm, and I am pro-farmer. And I see you the sponsor of this bill, and I want to focus my questions on the bill. Representative Noem, many on the minority side are concerned with some of the language that is not clearly defined in Section 3, specifically the, quote, nuisance dust, end of quote, as defined by, quote, other activities typically conducted in rural areas, end of quote, is causing concern for me and others because it may exempt many other industrial activities from Clean Air Act regulations. You're the sponsor of H.R. 1633, and is it your intention to provide exemptions for other activities not associated with standard agricultural practices in Section 3? And if not, would you be amenable to modifying this language in order to make clear the bill's intention?
Well, thank you for the question, Representative Rush. And I certainly believe that the title of the bill and the language of the bill is very clear, that it means to address farm dust and nuisance dust throughout the piece of legislation. I think that some of the interpretation that it goes too far and might include things such as coal ash and other harmful pollutants is that my bill simply does not exempt anything from regulations. It simply gives states and localities the flexibility to regulate dust in rural areas on their own. Now, if there are no local regulations that address in this place, federal regulations will certainly apply if the EPA if the dust proves that it has negative health benefits and if it does a rigorous cost-benefit analysis. So I believe the legislation as it stands today with the title that it has and with the language it has within it clearly defines nuisance dust and what is to be regulated, and that the states and local governments certainly have the opportunity to address the concerns that may be particular in one area.
Well, you feel quite strongly that your bill is necessary in light of the fact that EPA has already come out and publicly stated that it would not propose any changes to the current standard of 10 p.m. or 10 micrometers for coarse particulate matter. Can you explain why do you feel so strongly?
Well, I feel so strongly because I think the fact that if there's a piece of legislation out there that guarantees that EPA will not take any action for the next year, that that's a benefit to our small farmers and producers across this country. That it's not that they wouldn't trust the EPA, but I certainly think that they would appreciate knowing that there is a guarantee on no changes for the next year. The second part of this bill is that it actually does define the difference between rural dust, nuisance dust, and urban dust, simply because of some of the testimony that I gave earlier that there's a big difference between the nuisance dust and that it has proven to not have the negative side effects and health benefits or detrimental effects that some of the urban dust does that you referenced when you gave your opening statement. There's a big difference between those two different types of dust that occur in this country, and that definition and clarity between the two will certainly help the industry as well.
Is there any, besides the industrial dust and particulate matter, is there any other dust classifications that are exempted or included in your legislation?
Well, I don't believe so. As far as what this simply does is to put that definition into place in statute, that there is a nuisance dust definition, and what is included in that is the naturally occurring dust particles that would happen and the difference between urban dust. And this gives clarity to the EPA. This makes their job easier. They can look at each of these two different types of dust and know specifically how to define them and what the adverse health effects are on those. And then it also allows them the opportunity to come into areas if the state and local governments do not.
Thank you, Mr. Chairman. I yield back.
Thank you, Mr. Rush. It is the custom of this committee that the chairman and ranking member will ask other members questions. So we have completed that, and I want to thank you all once again for introducing the legislation and for...
Mr. Chairman, you're not going to allow other members to ask questions of this panel?
Would you like to ask some questions?
Yeah, I'd like to ask some questions.
Okay. Without objection, then I recognize the gentleman for 5 minutes.
I just want to take issue with some of the things that have been said because I think you've oversimplified it to the point where I think your conclusions are incorrect. First of all, the title of the bill has no legislative effect. What has legislative effect is the wording of the bill. And you've made a couple of statements, Representative Noem, that I take issue with. You said there's no proven difference between, there's a proven difference between urban and rural dust.
I said, thank you, Mr. Representative Waxman. I appreciate that. What my statement was or should have been was that the scientific research is very different, showing the detrimental effects of urban dust versus rural dust, that there's much different research data that's available on the detrimental health effects of urban dust as whereas there's...
The Clean Air Act doesn't regulate dust. The Clean Air regulates harmful pollutants. And in this case, we're talking about two kinds of pollutants. We're talking about fine particulates and coarse particulates. The standard was originally set when President Reagan was president, and it has been reviewed, but this basic standard has been in place. Now, you said that there's no proven adverse health effect from rural dust. If that rural dust is produced by farm machinery, that could have harmful impact, couldn't it?
It could, but we could speculate all day. What I prefer to operate with is the facts that we have in front of us.
Well, the facts we have in front of us is your bill defines this nuisance dust, which is a new term in law that you would propose to put in law, and it says particulate matter generated from natural sources, okay, unpaved roads, agricultural activities, earth moving, or activities typically conducted in rural areas. And I mentioned in my opening statement there are a lot of things conducted in rural areas which could add to the particulate matter, which, particularly in the area of fine particulate, is a genuine threat to human health. The point that I'm raising is that your intentions seem to be, both of you, pretty reasonable. You don't want the dust in rural areas regulated, as Congressman Hurd said. If you're going to try to stop the dust coming from farms, you'd have to close down the farms and lose the jobs. No, that doesn't make any sense at all. But the problem is nobody's proposing to do the things that you fear might happen. If you had a one-year period of time in which there could be no regulation on coarse particulates coming from dust in the rural areas, well, that could give somebody certainty for a year. Nobody's planning to do it anyway. But I fear that your bill is drafted in a way that goes much further, and it doesn't sound like that's your intention. Representative Noem, I mentioned in my opening statement that it's a non-existent problem, and we have so many real ones that should be addressing. There was an editorial my staff brought to my attention from a newspaper. It's the largest newspaper in South Dakota, and it said, there are important issues at the federal level right now that will have direct impact on our state, so it's disappointing to see Representative Kristi Noem continue her fight against a made-up problem like the potential for farm dust regulations by the Environmental Protection Agency. Dust has become a lightning rod for some Republicans, drumming up fear in farming communities that more federal government intrusion and over-regulation is coming to take money out of their pockets. Noem proposed legislation that would ban the EPA from regulating farm dust for a year, and similar legislation was advanced by Senator Mike Johanns. The problem is that the EPA has reportedly, and at every turn, said it has no intention of regulating farm dust. On Monday, it went as far as to write a letter to Congress stating it would not be regulating dust kicked up by combines. That should put the issue to rest. With those multitude of assurances that this is a phantom issue, what's your response to this editorial?
Well, Representative Waxman, that editor of that newspaper certainly doesn't represent my farmers and ranchers across South Dakota. And it's clear that he doesn't understand the bill, because in that editorial he didn't address the fact that it's going to provide a clear definition between nuisance dust, rural dust, and urban dust. He simply
well, let me take exception. Excuse me. Let me take exception. You state that as a fact, but there's nothing in the law that says this dust is from rural areas, this dust from urban area. It's different. The difference is only the amount of particulate matter in the region, and particularly if it's non-attainment, which is not attaining what is the health standard. When I was a young member of the State Assembly in California, I heard that there might be a freeway coming through. I asked for 30 seconds more, and I went out of my way to make sure that we fought that freeway and it was stopped. Turned out they never intended it, but the people in my district thought I stopped it anyway. That's a good thing to do politically, but when you change to something like the Clean Air Law with a lot of unintended consequences, I fear for that. If there were a chance to go through this legislation, maybe we can change it in some way, but I fear that your bill goes too far. Thank you, Mr. Chairman.
Mr. Waxman, your question. Yes, Ms. Noem.
Well, I just wanted to make a statement that certainly the people in South Dakota recognize that they recognize the need for this piece of legislation, or else I wouldn't be bringing it. But they've been talking to me about it every single meeting that I have, that people that deal with rural industries in South Dakota. I think when you hear the personal story of Kevin Rogers a little bit later, you'll really see what the impact
where there's a non-attainment.
But certainly, right now,
people who are fearful. You're going to ease their fears.
Okay.
Whether it's whether it's realistic or not.
We all get excited about dust, but let's calm down here a minute and
settle the dust on.
Yeah, let's settle the dust here. But Mr. Waxman raised some dust, and now Mr. Shimkus would recognize Mr. Shimkus for 5 minutes of questions.
Thank you, Mr. Chairman. And a couple things. Kristi, how far is your home from a paved road?
Well, my home particularly is not too far. It's about a quarter of a mile from a paved road, but our farm is about 8 miles from a paved road.
And is that chat, as I would call it, or is it dust? Or is it a
what?
dirt road, or is it a limestone rock road?
It's a dirt road. It's a gravel road.
So if it's gravel, and if there is an air monitor placed on that gravel road, which is 8 miles from a paved road, the gravel road probably would not be in attainment of the PM10 standard when the big four-wheel drive Hemi pickup truck with the horse-drawn trailer goes down that road. Isn't that correct?
I would agree. I would say virtually every single field during harvest time would be a non-attainment, as every combine goes through the.
And I have a photo that I showed Administrator Jackson when she first testified, and I'll probably pull it up later on. And it is this time of the year when we are finishing cutting of beans. Mm-hmm. And it shows a plume. Now, some people would say, oh, there it is, right there. That's right outside my hometown, just north of Collinsville. Now, if you had an air monitor right behind that, it would probably set off. Mm-hmm. But that's not diesel. That's just chaff. That's organic. That's leaves. That's stalk. And that is what we call cutting of beans.
Is that natural? Is that natural, Dennis?
Yes.
So my point is, in rural America, where the air monitor is, could determine, and the difference between urban America and rural America is that dust cloud will disperse way before it's in any concentration that would kick off. So a concern. And so the additional regulation imposed is a severe threat to rural America. You have how many agricultural groups in support of this bill?
Over 100.
Are they just crazy? Are they? I mean, are they just saying? So, are they just meddling? They have nothing else to do than be worried about the EPA?
Well, Representative Shimkus, if I could say one thing that Representative Waxman continued to say over and over is that dust is not currently regulated, and it is. The EPA does regulate dust, and the staff did recommend tightening those standards. So when he believes that there's no concern, there is valid concern in rural America.
Robert, you want to add anything?
Well, I would just say a couple of things. When we are asked whether or not we need this bill, to me the question ought to be, why don't we use our legislative prerogative to guide policy in this country? I think if you talk to the people I represent, they say for far too long the Congress has wholesale given its legislative prerogative over to agencies like the EPA, who are not elected, who are not accountable to the people. So why on earth would not we take our responsibility as being a voice for the people seriously? And why would not? What objection could one have to exercising that legislative authority that's been given to us by the people we represent? Going back again to some of the questions that have been asked about the actual standard, there's nothing unreasonable about Section 3 and the standard that is proposed. It just says there must be shown substantial health risk, and that there is a cost-benefit analysis that goes through and proves that the benefits outweigh the costs. So I don't think anybody's suggesting that you have and in my district, my rural district, we have power plants. No one's suggesting that emissions from power plants be exempted in any way, and this bill would not do that. And then finally, as it relates to the fear-mongering, and I take issue, and I wish Mr. Waxman were here, I take issue with his suggestion that this is somehow politically motivated. I talk to farmers in my district all the time whose fears of government regulation are real, and they translate to lower productivity and fewer jobs, and all they're trying to do. In instance, that I have a farmer in Nelson County who grows. He's a fruit grower. He says, I get regulated by the Department of Labor, the Department of Transportation, the IRS, the USDA, the EPA. He said, all I'm trying to do is grow peaches. I've been doing that for 5 generations. How hard can it be?
Yeah, let me reclaim my time and just recognize Corey for a unanimous consent request.
Thank you, and I just would like to ask permission for the record to submit letters of support from well over 100 different organizations that support H.R. 1633, NFIB, Chamber of Commerce's, ag groups, farm organizations, business groups.
Without objection. Thank you very much. Once again, thank you all for taking time to be with us. We appreciate it and look forward to working with you on this issue. Thank you.
Thank you, Mr. Chairman.
This time I will call up the Honorable Gina McCarthy, the Assistant Administrator for Air and Radiation, U.S. Environmental Protection Agency. Ms. McCarthy, we welcome you back to Capitol Hill, which I'm sure you enjoy coming up here a great deal. And
it's always my pleasure, Mr. Chairman.
Sorry we don't have some refreshments for you this morning, but we do appreciate your being here very much to testify on H.R. 1633. And at this point, I would recognize you for 5 minutes for your opening statement.
Thank you, Chairman Whitfield, Ranking Member Rush, members of the subcommittee. I appreciate the opportunity to testify in the Farm Dust Regulation Prevention Act of 2011. This sweeping bill could roll back Clean Air Act protections and adversely affect public health in urban, suburban, and rural areas. The bill has been sold as a narrow one. If all this bill is intended to do is prevent EPA from tightening the coarse particle standard, the bill is simply unnecessary. Administrator Jackson committed in an October 14, 2011 letter that she is prepared to propose to keep the PM10 standard, or coarse particle standard. National Ambient Air Quality Standard will remain unchanged if the administrator's proposal, as intended, is moved forward. I am hopeful that this announcement ends a myth that the agency has planned to tighten the regulation of farm dust. Whether intended or not, we're concerned that this bill does far more than its sponsors have indicated. It could prevent EPA from regulating power plants or other major industrial sources of pollution in urban and suburban areas, as well as in rural areas. This is because Section 3A takes away Clean Act authority to regulate nuisance dust and then defines nuisance dust very broadly. And it includes particulate matter generated from activities typically conducted in rural areas. This exemption would cover both coarse and fine particles emitted from anywhere in the country and might include pollutants like NOx and SOx that form fine particles. This would appear to preclude EPA from regulating particle pollution from activities such as power plants, mining operations, industrial operations, and construction anywhere in the country, because those activities are not atypical to occur in rural areas. It could even call into question EPA's ability to enforce or set tailpipe emission standards that would limit particle pollution from cars, trucks, and buses, because those same cars, trucks, and buses typically drive in rural areas. In other words, the Farm Dust Bill might forever bar the EPA from limiting emissions of coarse particles, fine particles, sulfur dioxide, nitrogen oxide, and mercury from power plants, industrial sources, and maybe even motor vehicles. We're also concerned that H.R. 1633 could block revision of fine particle standards and implementation of existing fine and coarse particle standards. Since the existing particle programs do not distinguish between nuisance dust and other particles, the bill raises the issue of whether the EPA could enforce or maintain existing fine or coarse particle pollution standards. The term nuisance dust is not a scientific term, which would make it very difficult to incorporate an exclusion of nuisance dust into a scientifically based program. This could raise practical concerns. It's unclear how one would design a monitor that measured fine particles except for nuisance dust, and it is unclear how the agency could implement particle pollution programs without a scientifically sound monitoring network, and it's certainly unclear what the cost would be to states or local communities to put in that type of a monitoring system, could one be designed and developed. The existing fine and coarse particle pollution reduction programs are important for public health. While nuisance dust sounds like it's merely inconvenient, it includes particle pollution that's harmful to public health. When we breathe, both coarse and fine particle pollution can reach the deepest region of our lungs and move past our body's filtering systems. We have a health-based standard for particles smaller than 10 micrometers since 1987. That's 24 years. Coarse particles have been linked to a variety of adverse health effects, including hospital visits related to cardiovascular and respiratory diseases and premature death. This is the standard that the administrator has announced she is prepared to propose to retain, not propose to change. In 1997, EPA added a health-based standard for fine particles, which cause serious health effects. Nationally, EPA estimates that exposure to fine particles results in, among other effects, 130,000 to 320,000 excess deaths in adults, 110,000 emergency room visits by children, 2.5 million cases of exacerbation of asthma, and 18 million lost workdays each year. I have briefly discussed some of the potential consequences of H.R. 1633. As written, this bill would significantly weaken EPA's authority under the Clean Air Act and significantly cause and preclude us from preventing public health protections that are necessary for the American people. If these consequences aren't intended, it would be best to revise the bill to avoid the confusion, litigation, and the concerns that I have raised. I hope this information that I've presented, as well as the Administrator's October 14, 2011 letter, clarifies EPA's intentions and obviates the need for this legislation. It is simply not necessary at this time to block the tightening of the PM10 standard, which the Administrator has very clearly indicated that she has no intention at this time of proposing. Thank you very much.
Ms. McCarthy, thank you for your testimony. You heard me say earlier that one of our concerns is that it doesn't make any difference what EPA decides or doesn't decide. Outside groups file lawsuits on a regular basis against EPA. And I think even you would admit and agree that frequently the court's decisions determine what the interpretation of the EPA Act is and what becomes law. So our concern is, even though Lisa Jackson says no, are you convinced that a third-party environmental group or some other entity would not file a lawsuit?
Mr. Chairman, as you know, the Administrator has made her intention clear, but certainly she can't preclude the rights and responsibilities she has under the Administrative Procedures Act and the right to listen to comment that's received. I would, however, say that the Administrator is basing her decision on a wealth of scientific information. I have the Integrated Science Assessment right here. She has taken the advice of the Clean Air Act Science Advisory Committee. She's listened to the staff recommendations, and she believes that the law gives her deference in making these determinations in terms of what the science said and what the
But you do still understand our concern about how many lawsuits are pending against EPA right now?
There are a number of lawsuits pending, but in the case
There's
of
over
PM10,
400, I believe, aren't there?
In the case of PM10, the administration has acted a number of times. First, under President Reagan. Second, under President Bush. In this administration, we believe the science is clear, and we believe that the administrator's recommendation will hold true.
Well, see, we agree with you. We think science is clear also, and that's why we think that moving forward with legislation would remove any ambiguity whatsoever. So that's where we stand on that issue. Now, as far as coarse particulate matter, does EPA have the authority to regulate coarse particulate matter now?
Yes. Yes, it does, Mr. Chairman.
And if the state implementation plan of a non-compliant area does not do so, EPA can step in. Is that correct?
Well, the EPA would have an obligation to step in if the state implementation plan didn't effectively address attainment in the way the Clean Air Act requires.
And how many states today are regulating coarse particulate matter because they are in non-attainment?
There are only a very few numbers of states that are regulating PM10. It amounts to about 41 counties. It's a very small area of the country at this point in time.
Do you believe yourself, from the evidence that you have read, that coarse particulate matter does have an impact on a person's health?
I do. I do believe that, and I think the scientific evidence is quite clear. And we have evidence not only that coarse particles that are emitted in urban areas cause problem, but there is clear scientific evidence that distinguishes what we call what people have called rural dust, that also causes significant public health concern.
Well, if you do believe that even rural coarse particulate matter does impact health, why did you all decide not to strengthen the coarse particulate matter regulation?
Well, the administrator has to establish a standard that's requisite to protect public health with an adequate margin of safety. The Reagan administration NAAQS standard set in 1987, 24 years ago, that was also revisited by the Bush administration and that is now being reconsidered by this administration, is actually a very sound standard. It is a standard that we believe is sufficient to protect public health. We believe that there is scientific uncertainty, which the administrator has been looking at and considering, that would lead her to retain the standard as it's proposed, but certainly that information is rigorous enough to indicate that we should retain the current standard.
Now, the current PM10 standard is 150 micrograms per cubic meter. Is that correct? Is that the current standard?
Yes.
And then there's a threshold of 99. What is the correct thing? 99 percentile. What does that actually mean?
Actually, that means, and that's one of the issues that has been most confusing, because the Clean Air Act Science Advisory Committee actually proposed to change the standard in the form, or actually asked the administrator, I should be clear, to consider a change in the standard in the form. The 99th percentile just really means that the area could be in non-attainment if they exceeded or had events that brought up the level of pollution to a certain amount just a few times a year, and it would trigger national ambient air quality standards. If you lower that percentile, it means it needs to be more often and more frequent in order to trigger non-attainment.
Okay, so the standard is 150 micrograms per cubic meter, and the form is 99 percentile.
That's right.
So if you exceed that 1% of the time, you're okay, but if you exceed it 2% of the
That's
time,
right.
you're violate.
That's right.
All right. Well, my time's expired. I recognize the gentleman, Mr. Rush, for 5 minutes.
I want to thank you, Mr. Chairman, and Ms. McCarthy. I want to welcome you again to this subcommittee. I got a little bit confused during the questioning from the chairman here. It seems that we were discussing the Farm Dust Regulation Prevention Act, but it seemed to me like he was talking about the EPA Litigation Prevention Act. He was trying to keep EPA from being in court, being litigated against in court. And I just don't know, do you think that that's within our legislative powers to keep the EPA out of court?
Chairman, Mr. Rush, I think that we actually are authorized to establish national ambient air quality standards. We certainly do that to our best of our ability based on the science and the law. Without question, it's often challenged, but without question, we win a considerable amount of the time because we do our jobs well.
Well, and I agree with you. You do your jobs quite well. We heard earlier from Representative Noem that the scientific research shows a clear distinction between, quote, urban dust and rural dust. And H.R. 1633 would make it simpler and easier for EPA by defining what nuisance dust is. Does the scientific research show a clear distinction between urban dust and rural dust? Also, does H.R. 1633 make it easier for EPA by defining nuisance dust as it is defined in this bill?
The definition of nuisance dust in this bill is very broad, and we are very concerned that it could have significant spillover impact in terms of our ability to regulate pollution from sources well beyond rural areas and well beyond agricultural sources. And we're concerned about that impact. I would also say that there are significant amounts of health studies, and they become more every time we look at the data. and every time we revisit NAAQS that show that coarse particles, whether they're generated in the rural areas or they're generated in the urban areas, have significant health consequences. They deserve to be regulated. The science demands it. The law requires it. EPA does that.
Well, so let me just ask you, is the matter that's the standard that was established in 1987 under the administration of President Reagan, has that standard been a threat to the farming communities in this nation, or has it been helpful?
We do not believe that there is any evidence that farming has been in any way significantly disrupted by any of the national ambient air quality standards. As you know, when we establish a NAAQS, it is a national standard. It's not targeted to a specific sector or a specific geographic area. I do know since 1987, when this was first proposed, there have been identified by states and local air quality districts when they implement in non-attainment areas. They implement their requirements to look at sources and identify what sources contribute to local health consequences. There have been times when they have worked with the USDA, they've worked with local farmers, they've identified best management practices, conservation measures that those farmers can put into place that would reduce the amount of dust that they emit and still allow farming to continue unabated. And there have been instances where we have worked in a collaborative way to help that effort and that outcome. And it's been an enormously successful opportunity for all of us, and to make sure that farming can continue, that it can continue unabated, and we can work with them to reduce the amount of dust that's emitted and maintain the health standards that are required to protect public health.
Yeah. Can you, I only have a few more seconds, there seemed to be the 800-pound gorilla in the room seemed to be the fear factor that is prevalent, or that some have alluded to in previous testimony at today's hearing. Can you comment on what your understanding of the fear factor is, and how great is it, and how significant is it?
Well, we heard quite a while ago, Mr. Rush, that there was concern in the farming community on the basis of the recommendations by the Clean Air Science Advisory Committee that the administrator consider a change in the standard. What was misunderstood was they were asking for both a change in the standard as well as the form. It actually would have resulted in fewer counties. It would have been a little bit more flexible, not so much sensitive to the high levels as much as averaging a little bit in a way that would have provided more flexibility. We did 6 listening sessions with the agriculture community immediately to explain to them what the process was, that it wasn't the recommendation of the staff, that the administrator didn't make a decision yet. And we also talked about all of the work that we've done together on farm dust since 1987 and the collaborative nature of that process and the impacts that hasn't happened as a result. And we will continue that effort. And now that the administrator has made it clear that she is not intending to propose a change in that standard, we are certainly hoping that it puts those fears to rest.
Mr. Shimkus, you're recognized for 5 minutes.
Thank you, and it's great to be with you, Assistant Administrator McCarthy.
Good to see you, too.
Yeah, we have a lot of fun here, and hopefully I'll be kind and courteous, and again, appreciate all the help that you've given in the past. A couple issues. It is true that Tier 4 engine regs, which has created additional costs for the agricultural community and diesel engines. Is that correct?
We do. The Tier 4 engine rules have been tightened, and it does require that they look at particulate matter and other emissions from those
So when you have diesel engines operating in rural America, you cannot say there's no effect on cost and production and operations when you've ratcheted down diesel engine emissions the clean air applications.
The engines that we regulate are very large engines.
Well, I mean, large engines are used in agricultural America.
I believe that I was referring to dust issues. So
I'm just trying to.
There are definitely requirements in the farming community when you have large farms that are significant individual sources of pollution, and they have to achieve the same kind of engine standards. That
production agriculture is large.
Yeah.
Operations and large engines. So I just want to put that on the record. There is an effect. To say there's no effect, that really can't be stated. You mentioned 41 counties that you know are in this, and I have one of the maps. There are other counties that continue to regulate particulate matter on their own. Is that correct? Virginia has fugitive dust. Mr. Hurt, I think, is left, but Virginia has fugitive dust regulations in Virginia.
I'm sorry, Congressman. I'm not familiar with that, but these are the requirements that are attributable to the Clean Air Act.
Just placing that into the record that there are states that are monitoring for dust in states on their own outside of the SIP and the requirements of the Clean Air Act. The fear factor that my friend mentioned is one of your statements in your opening statement said, "at this time." Using that terminology, "at this time," creates a fear factor in rural America because tomorrow you may. At this time versus tomorrow. The importance of legislation is to codify that, to say, not at this time. No more. PM10. In fact, the letter that the administrator sent to Lisa Jackson Lisa Jackson sent to Debbie Stabenow, "I am prepared to propose retention with no revision of the current PM standard and form when it is sent to OMB for interagency review." Now, the question is, so the administrator must believe that PM standard as it is currently operated under the EPA, that it protects public health. Is that correct?
Yes, adequate with an adequate margin of safety. Yes.
And you would agree with that?
Yes.
So, good. I want to have that on the record because that's part of this whole debate of the concern of rationing it down. You heard doing the opening questioning and just the difference of concentration. A lot of our experience here on the committee is focusing on concentrated amounts that affect human health. Do you agree that concentrated particulate matters can be harmful to human health?
I believe that exposure to particulate matter can be
in any concentration or in certain concentrations.
It depends on both. It depends on the concentration as well as the size of the particle.
But you just said PM10 is safe.
No. I said that the National Ambient Air Quality Standard was appropriate as a safeguard for public health protection. That does not mean that I think that it's safe for exposures at all levels. Certainly our goal is to achieve the National Ambient Air Quality Standard that's required under the Clean Air Act. I'm making no statement about my independent knowledge of health consequences associated with exposures beyond that.
Thank you, Mr. Chairman. Time's expired.
Yes, sir. This time, recognize the gentleman from California, Mr. Waxman, for 5 minutes.
Thank you, Mr. Chairman. Ms. McCarthy, we heard from some people that the Republicans want to make common sense changes to the Clean Air Act, but in reality, I fear they may be making some radical changes, and you said in your opening statement, the bill does far more than prevent a change in the coarse particulate standard. We believe it could result in far-reaching damage to the bedrock public health protections in the Clean Air Act. Now, the bill includes a broad definition of so-called nuisance dust that would be exempt from EPA regulation. The bill lists several examples of what falls under the category of nuisance dust, including, quote, earth moving, end quote, the bill doesn't limit this to farms. Ms. McCarthy, could the operations of a large open-pit mine fall under the category of earth-moving?
Yes.
In fact, during the next panel, we're going to hear from the Coarse Particulate Matter Coalition, an industry association that supports this bill. One of the coalition's members is Kennecott Copper, which operates one of the world's largest copper mines in the world. That company would like to expand its mine with fewer air pollution controls. So that's one way this bill goes beyond farms. The bill also includes, quote, wind-blown dust, end quote, in the definition of what constitutes nuisance dust. Ms. McCarthy, could all particulate air pollution be viewed as wind-blown dust? And does the bill distinguish between particulate matter from a farm or from a factory?
It could, and there is no such distinction in the bill that you've asked me to comment on.
So the dust is undefined in the bill and commonly applies to small particles, so all particulate air pollution might fall under this phrase.
It might.
Okay. The bill further includes as nuisance dust particulate matter that is generated from, quote, activities typically conducted in rural areas, end quote. This is extremely broad and could capture a range of industrial activity that often occurs in less populated areas. Ms. McCarthy, what activities could be covered by this definition?
The generation of power at a power plant, large industrial sources like steel plants, gravel operations, mining operations, driving diesel buses to school. So there diesel engines, a variety of the same kind of sources that you would find in rural areas can be found in urban areas as well.
The bill is so broadly written that it could prevent EPA from ensuring that school buses don't spew dangerous air pollution in rural communities across the country. I think that's not common sense. I think that's ridiculous. Ms. McCarthy, given these broad definitions, how could this bill affect EPA's ability to limit emissions of particle pollution from all sources, not just farms, and what are the public health implications?
This bill, if passed as written, could have serious implications on the major tenets of the Clean Air Act. It could preclude us from regulating PM fines as well as coarse. It could preclude us from regulating NOx and SO2 emissions from power plants, from mining operations, from large industries, from mobile sources. It could have serious unintended consequences.
If the Republicans want to reduce or eliminating existing controls on particulate pollution from industrial activities, they probably have the votes to do that. But if so, let's debate that on the merits. Let's not pretend that this bill is about stopping EPA from imposing new regulations on farms. I hear this all the time, and I've heard it all my career. I've got a simple bill. It's only common sense. It only deals with a problem that is on people's minds. And then you look at the language, and you find out that it's much broader and has a lot of consequences that we presume are unintended, but they might even be intended. So I think we have to look at legislation as it's written, not as how people would say it's intended, because their intentions are not part of the law that EPA enforces. Isn't that correct, Ms. McCarthy? Does EPA enforce intentions of the authors or the language of the bill?
We have to enforce the language of the bill, Mr. Waxman.
Even if Congress intended something else?
Oftentimes, yes.
Okay. I yield back my time. Thank you, Mr. Chairman.
Yes, sir. At this time, recognize Mr. Terry, Nebraska, for 5 minutes.
Thank you, Ms. McCarthy. While I'm listening here and some of the discussion about whether or not we should even be having this discussion, and the EPA has already said they won't enforce this, their PM10 on agriculture was a statement I think Lisa Jackson made when I asked her about that, and after she answered, dust happens. As the answer, I thought that was rather flippant and insulting to our farmers. But the reality is the fear exists, and I do think it's real, not only because there was a recommendation to regulate dust on the farm and the roads, But there's been a history with this EPA, for example, in the state of Nebraska. Under a proposed rule for Casper, Nebraska was not even given reasonable notice or opportunity to revise its implementation plan to react to requirements of the 206 PM 2.5 NAAQS. And it wasn't until August 2011 that Nebraska became aware that a level of emission control necessary to mitigate interstate transport. So the point is, those of us in Nebraska have already gone through a situation where the EPA said basically you weren't going to be covered, and then to our surprise we were covered, which resulted in a lawsuit. So there's a history with the EPA of making promises and then breaking them. Now, in regard to the specific of nuisance dust and PM10, the chairperson, Chairman Whitfield, hit on this, and it's always been my saying that we're only one lawsuit away from you being forced to regulate dust particulates from farming activities or the roads. And in fact, there's a history with the EPA of their partners, Sierra Club and Natural Resources Defense Council, filing lawsuits and then you entering into settlement agreements. So with that fear that I have, that's the ultimate plan here, is to have one of your partners file suit. Therefore, it's not Lisa Jackson's or this administrator's decision, but the court's decision. I used the fictional because that's what happens. You enter into a settlement agreement. So my question to you is, to your knowledge, has Lisa Jackson, you, or anyone with the EPA had any discussions with Sierra Club, the NRDC, or any other environmental group about filing lawsuits on nuisance dust from farming activities and dirt roads?
Absolutely not.
No discussions?
Absolutely not.
No emails?
Absolutely not.
Okay.
Mr. Terry, we can talk about the cross-state rule another time. I would really like that opportunity. But what I will say is that this whole issue arose because people were concerned about the administrator going out and making a change in a standard that was had never been brought to her. The rule has not been proposed. She has indicated what she intends to propose. It would go through a public process, and then it would be finalized, and without doubt it will be challenged. There is ample opportunity for this body to see whether the administrator is actually going to live up to the letter that she wrote, and whether or not the science is in what the final rule looks like.
Listening to the discussions that have occurred so far, you would agree that basic combining harvest or plant would create dust that would then, in that instance, violate the PM10.
Actually, that's not how it works. We actually rely on monitoring technologies, not modeling from individual sources to establish non-attainment areas, and we don't have farm dust standards.
But we already have an example in Virginia where the monitoring said that at that particular time of the truck driving over the road violated the standard. And so the reality here is that we are only one lawsuit away from you being forced to enforce the rule on farming activities. And my time is up.
Thank you. At this time, I recognize the gentleman from Massachusetts, Mr. Markey, for 5 minutes.
Thank you, Mr. Chairman, very much. In 1999, the public was outraged to learn that Congressman Tony Schnell had introduced Bill 602P to allow the United States Postal Service to impose a 5-cent tax on every single email that was sent. Email action alerts were sent out with alarming instructions to read this if you intend to stay online and continue using email. Congressional offices were flooded by frustrated constituents. The issue even got raised at campaign debates where candidates predictably came out in opposition to this misguided scheme. There was just one problem. None of it was real. There was no Bill 602P. There wasn't even a Congressman Schnell in the House of Representatives. The whole thing was an internet hoax, and everyone should have just moved on. But the Republicans forged ahead. They introduced the Internet Access Charge Prohibition Act of 1999, apparently because only by passing actual legislation to prohibit the goals of the imaginary legislation authored by a fictitious congressman could we prevent these horrible surcharges from being imposed in the real world. But it didn't just do that piece of legislation. Then it went on further to actually include provisions which would have hurt poor and rural Americans to get phone service. So I'm reminded of that legislation as we consider this bill to prevent the regulation of farm dust. Just like the email tax hoax, there is no plan to regulate farm dust any more than there is to regulate fairy dust. There is no attempt to accomplish that goal. Let me say that again. EPA has made it very clear that the so-called plan to regulate farm dust is a myth. But that hasn't stopped the Republicans from moving forward with this legislation. And just like the email tax bill, this bill goes well beyond its stated intent because it also blocks EPA from setting standards for the dirty soot that gets spewed out of coal-fired power plants, incinerators, refineries, and chemical plants. That's the real agenda, not to stop something that isn't going to happen, but to then switch in the middle of their legislation to move over to something that really would protect the public from public health hazards. This bill should be relegated to the dustbin of similar urban legends, along with Congressman Schnell's imaginary email tax bill. Ms. McCarthy, can you tell me whether EPA has any new plan to specifically regulate farm dust?
We do not.
You do not?
We do not.
Isn't it true that this legislation goes beyond a simple prohibition on farm dust regulations by also preventing EPA from regulating any dust that is generated by activities that are typically conducted in rural areas and any dust that can be blown in the wind?
That's true, Congressman.
Even if that dust is actually coming from coal-fired power plants or other industrial sources?
There is a grave concern that that is part of what the bill might do.
And finally, since I am sure that many little girls all over America care about this deeply, can you commit to me that EPA will never try to regulate fairy dust or pixie dust? Because if not, we may just want to amend the legislation in order to protect us against that threat, which could be posed by the EPA or other regulatory agencies seeking to move into other fictional areas, such as the legislation which is being considered here by this committee.
After we look at the complete scientific review, yes.
You will make sure that you do not, under any circumstance. Okay, thank you. So I thank the chair very much and I yield back the balance of my time.
This time, I recognize the gentleman from Texas, Dr. Burgess, for 5 minutes.
Thank you, Mr. Chairman, and thanks, gentlelady, for being here with us today and answering our questions. You've brought a lot of material with you there at your left hand. What is that compendium of documents?
This is the Integrated Science Assessment for particulate matter, that has recently been prepared that would underpin the decision of the administrator in terms of moving forward with updating both the PM10 and the PM2.5 standards.
And there are health studies included in that?
This is actually a peer-reviewed summary of peer-reviewed scientific literature that would have an impact in concern relative to particulate matter. Yeah.
So are there available then health studies that have found that rural dust is a health concern?
There are many, yes.
And will you leave those behind with us?
Absolutely.
Has the EPA conducted a quantitative health risk assessment of coarse particulate matter?
The EPA has not used that tool on coarse particulate matter, no.
Is the reason for that because you don't have enough scientific evidence to proceed?
The reason
with?
for that is because coarse particulate matter, we don't have the kind of monitoring data that we have available relative to other pollution. So that it doesn't seem like it would be an appropriate tool to use. But we certainly have enough studies that look at coarse particles so that a linkage has been made in terms of the emissions of those particles and health impacts that would result.
Well, let me ask you this. There was another subcommittee of Energy and Commerce that asked Administrator Jackson to share with that subcommittee any studies that show a causal or associative relationship between fine particulate matter and deaths at levels below what the EPA calls the lowest measured level. Now, apparently that request has yet to be honored, so can I ask you today that you will endeavor to help us receive those materials that Administrator Jackson promised the another subcommittee of this full committee?
I will assure you that we will provide all of the health studies that are the basis of these decisions.
All right. We'll get you the details on that, but I think it is important, and I appreciate your willingness to help us gather the information. Let me just ask you a question that's a little bit off topic for a moment. Now, it seems like Administrator Jackson and the EPA are very concerned about asthma and asthma deaths. Is that a fair statement?
Yes.
Seems like almost every hearing we have on almost anything, asthma deaths are brought up as one of the metrics.
Well, air pollution generally, the health impacts of most concern are usually respiratory or cardiovascular, yes.
Well, one of the things that's just really perplexing to me, I'm an asthma patient. I'm on a long-term medication, and I also use a rescue inhaler. Now, occasionally, like anybody else, I'll forget my medication. I travel a lot. And it's reassuring to know that I can go into any pharmacy in the country and buy Primatene Mist over the counter. I don't have to go to the emergency room. I don't have to get a doctor's prescription for it. I can just simply get the medication when needed and self-administer and avert a problem. But Primatene Mist is not going to be available after January 1st, is it?
That's correct. If the FDA ban continues, yes, that's true.
Well, it's not just the FDA. I mean, the EPA is playing a role in this as well because of the propellant, the vehicle, the CFC,
yes,
that actually propels the medication.
Certainly, we have been working closely with FDA for many years on this issue, yes.
But the fact remains that because of the EPA, this medication is no longer going to be available to me after January 1st.
Well, the fact remains, I think that just to clarify, this is an issue where there are CFCs that actually are used in these inhalers, both in the ones you get by prescription, and there is one remaining that's over the counter that has an impact on ozone layer, and as part of our obligation under the Montreal Protocol.
I would submit that the volume of CFC that is released into the atmosphere from the contingent of asthma patients that uses an occasional rescue inhaler that they buy at 2 o'clock in the morning is vanishingly small and not responsible for the hole in the ozone layer. And I will tell you, my own comfort at 2 o'clock in the morning takes vastly more precedent than any potential theoretical enlargement of the hole in the ozone layer. I just got to say, here's an example of we come in here and we talk about in lofty terms that we want to prevent asthma deaths, and yet at the same time, the EPA and the FDA in concert are acting to keep the medication out of the hands that the patients who so desperately need them. It is irony to the nth degree, and I thank the chairman for allowing me the indulgence.
I'm happy to have the discussion and bring back the dialogue relative to FDA's determination as to whether or not this inhaler is an essential use.
Look, you're not going to get me defending the FDA, I promise you that, but both federal agencies are playing a role in this, and the fact remains, January 1st, patients all over the country are not going to be able to get their access to their medication. If we're concerned about asthma, we would fix that.
Well, thank you, Dr. Burgess, and we appreciate you raising that issue of sometimes unintended consequences. At this time, recognize the gentleman from Louisiana, Mr. Scalise, for 5 minutes.
Thank you, Mr. Chairman. I appreciate you having this hearing, and I want to thank my two colleagues that were presenting the legislation that we're discussing today. I strongly support the legislation and what we're trying to do is, I think, bring some certainty to an area where there's tremendous uncertainty, and unfortunately, the uncertainty has cost jobs. It's cost a lot of businesses. What we're seeing over and over from businesses in my district and other districts, when you talk to colleagues all around the country, you hear the same thing over and over. It's not only the uncertainty, but the actual threats from real regulations or potential regulations coming down from agencies like the EPA that are impeding their ability to create jobs, that are impeding their ability to invest in their businesses. And I'm looking forward to the next panel because we're going to hear from some people who are actually on the ground dealing with this. And you know, while unfortunately some of my colleagues on the other side want to make fun of this and, you know, want to tell jokes about fairy dust, this is about real American jobs that are being lost because of these regulations. You know, and yet some people just want to make fun of that. They think that's funny that people in middle America, people in rural America are looking at these regulations that are coming down and looking at the threats. And I want to read to you some, this is off of EPA's website. You know, you're talking about some potential diseases coming, respiratory irritation, lung function reduction, asthma, inflamed damage to lungs, aggravated lung disease, permanent lung damage. And I know you rattled off some other things in your opening testimony. I'm not talking about dust particles. I'm talking about the ozone ruling. These were all the same things that EPA said were threats that you needed to have this ozone ruling. And even President Obama said, you're out of control. He pulled it back. And so when you come before our committee, and no matter what bill it is, if it's cement mac or boiler mac or dust or ozone, you rattle off the same things over and over about, you know, if we don't allow you to go forward with this, or we bring a bill to prevent some radical regulation from EPA, it's going to send more people to the hospital, and kids are going to get asthma and you know, lung disease. You know, you've been beating that drum for everything, and even the president said that you're out of line. And so I hope, you know, when y'all come and oppose these common sense bills to just put certainty in place, to prevent some regulations from coming in that aren't there now, that would put people out of business, when you keep saying the same things over and over about threats to health, I mean, are you saying that the president doesn't support public health? Because the president said you went too far.
I guess I'm a little confused because I think this bill was initiated because the administrator actually made it clear that she doesn't intend to propose a change in the PM10 standard at this time.
But then you should be okay with the bill. Because the bill just says
bill,
then you won't go forward with it. You're saying you're not going to do it. The thing is, you've said you're not going to do it on other areas. Not you personally, but EPA's done this in the past. And the chairman brought this up. The chairman of the committee talked about these consent decrees, these consent agreements that some of these outside groups will come and sue the EPA, and we've seen it with energy production, we've seen it with other things, and then y'all go into an agreement with them. It's not a law, it's not even a rule, and yet you can go into these consent agreements and all of a sudden there's a new standard on the books that nobody agreed to. It wasn't members of Congress that agreed to it, the elected representatives of the people. It was some backroom deal cut, either by a judge or even worse, some outside group who's a special interest that got together with y'all, and y'all came up with some kind of new agreement. Now everybody's got to comply with it, and it puts people out of business. It kills jobs in this country. And we're just trying to say we're going to issue a preemptive strike before y'all are forced in that position. You might not even want to do it. But if they bring you to court and all of a sudden some judge gives some ruling, everybody in America, rural Americans, all these farmers have to comply with this stuff now, and it costs them jobs. And we're just trying to say, before you cost any more jobs, because you've already cost jobs, whether you agree with it or not, we can bring in business owner after business owner and job creator that can tell you thousands of jobs in each industry that have been lost because of EPA regulations. We're just trying to say enough is enough before this new one comes out. Let's stop it. And what's so wrong about that when you look at all the outside groups? You're looking at over 100 farmer groups, U.S. Chamber, National Association of Manufacturers, all these farm groups. I mean, I saw a story from the Illinois Farm Bureau. I mean, do you think they're just making up stuff? Do you think they're having imaginations about fairy dust as it was suggested? I mean, these are people that are on the ground trying to just create jobs, and they're scared to death of what's coming down the pike from EPA.
Congressman, this The language in this bill goes far beyond the interest that you've expressed in making sure that the administrator's decision to not propose to change the.
All right, so if you don't like the language, then what you're saying is you're okay with some kind of prohibition, you just don't like this language.
All I'm suggesting is that this law is not necessary.
I think a lot of hard-working farmers out there would
And the only other
would disagree, but I yield back. I'm out of time.
Gentleman's time has expired. Recognize the gentleman from Colorado, Mr. Gardner, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Ms. McCarthy, for your time here today. I truly appreciate it. We've talked a lot today. EPA currently has a PM10 standard, dust standard. Is that correct?
Yes.
And that basically means 150 microns per cubic meter of air at the 99th percentile. Is that
That's
roughly
correct.
what it means? Which means you get about 3 days over the standard averaged over a 3-year period, and you're still in compliance. Is that correct?
Yes.
Okay. Does that standard apply across the country?
Yes.
Are there areas of the country that are in non-attainment for PM10?
There are.
And where are these areas?
Well, I can certainly point them out to you. For the most part, they're in the western part of the U.S. I'm certainly happy to share this with you.
Southern
But
California,
these are
Arizona.
the 45 areas. That's right.
Thank you.
Primarily.
Do any of these non-attainment areas have any agriculture production?
Yes, many of them do. I think it is primarily around urban areas where we monitor most closely.
What requirements are placed on those producers if they farm and are in a non-attainment area?
It all depends. They may not be seen as contributing significantly to the non-attainment, in which case there's no obligation. In areas where they've been identified, which represent a couple of counties that I know about, there are a number of best management practices that have been developed with USDA and the farming community. They tend to choose what's most appropriate off that list and implement those measures.
Well, I'm glad you mentioned that because, in fact, since there's nobody on this committee from Arizona, I do have where some of the non-attainment areas are. I would like to ask that these documents be submitted to the record. Arizona's mandatory BMPs, best management practices for row crop agriculture, and mandatory BMPs for livestock producers.
Without objection. Thank you.
Thank you. And it seems that based on these documents, they're the results of the PM10 standard that are set by the EPA that you currently regulate to farm dust. That's what these documents are here for, because of the regulations on dust that occurs in agriculture, farm dust. Now, I understand. I live in Colorado. It's very dry. I would love to ban dust. It seems like that's all we do is dust. We've worn the coffee table out with it. But I was just curious, your statement, and I've heard others say that it's a myth that EPA is trying to regulate dust, but you already do. Is that correct?
Actually, we establish health-based standards. It's up to the states and the local communities to determine what's
dust,
most
right?
appropriate to regulate.
You do regulate dust.
We establish national ambient air quality
The answer
standards.
is yes. You'd regulate dust. I mean, that's why you have these best management practices here that are about farm dust.
I believe that is a regulation in Arizona, and it's being proposed.
So Arizona just has this regulation not because of the EPA?
No, it is very directly a linkage because of the health consequences associated with coarse particles, some of which may be from farms if they determine that they're significant
Which is farm
sources.
dust, and so you are causing them to regulate farm dust.
We could probably continue this for
Well,
a
that-
while,
see, this-
but
this is
we
what's
do
so-
not. We do not directly regulate farm dust. We have no farm dust regulations. What we have is national ambient air standards that regulate coarse and fine particles, which many businesses, industries, as well as some
So let me rephrase
agricultural.
the question. Do you regulate dust from farms? I mean, maybe that's a different question. Farm dust, maybe there's no specific category for defining farm dust, but do you regulate
I really don't. I'm not
matters from
trying to be
farms?
evasive. Let me tell you how.
But see, the problem here is that's what my district sees. This district is the 11th largest ag-producing district in this Congress out of 435. It's not fairy dust to them. This is a very real issue.
I'm not suggesting this is not a serious issue.
EPA also suggested that they weren't going to regulate milk from dairies, but they had to actually put something in their milk spills at dairies, but they had to put something in the federal regulations saying they weren't going to regulate milk spills. You can see the problem that we face when it comes to the EPA and how our farmers and ranchers are trying to deal with it. We have best management practices from states that are dealing with the regulation of dust from farms. Now, whether that's farm dust or not, maybe that's a point of distinction.
In areas where farm dust contributes to non-attainment and imposes health concerns in those communities, there is certainly both a right and an obligation to take a look at those issues and to see if there are cost-effective practices that can be put in place that would reduce the health consequences associated with those emissions. So I don't see anything wrong with that. In fact, I see that as a good practice to continue.
So do you think there should be regulations on dust from farms?
I believe that there should be regulations on coarse particles, and then when coarse particles, no matter where they are emitted from, can be reduced in areas where they are causing a health burden, that they should be reduced if they can be done cost-effectively
So the answer is yes,
and practically.
dust from farms ought to be regulated.
I did not say that, no.
The gentleman's time is up. This time I recognize Mr. Pompeo of Kansas for 5 minutes.
Thank you, Mr. Chairman. Thank you, Ms. McCarthy, for being here today. I want to spend some time on the statute, but first I do want to clarify. Mr. Markey didn't take this very seriously. He talked about fairy dust. He talked about myths and fake congressmen and fictitious things. Do you agree with him? Is this a myth? Are the 100 folks who signed that letter in support and everybody who talks to me back in Kansas, are they irrational, ignorant, or just sadly misled?
I think there are many misunderstandings here, and there's complexities here that people don't understand. I certainly understand that the agricultural community is concerned. I do recognize the importance of the agricultural community, and we certainly don't want EPA to look like it's adding burden on the farming community when, in essence, the administrator has clearly said she has no intention of proposing a change in this PM standard. All of that is very real.
Well, I appreciate that. So you disagree with Mr. Markey. You take this seriously.
I take my job very seriously.
I appreciate that. I want to talk about what the proposed legislation does and what does not do. There was Mr. Waxman talked about this eviscerating, gutting the Clean Air Act. I think that's the 57th time I've heard that in 10 months. Everything we do guts the Clean Air Act. He talked about taking away, eliminating regulation. This doesn't eliminate any regulation. This just gives the states the ability to do it. And if they don't do it adequately, you can come in and clean up their mess. Isn't that right? Isn't that, as I read this language, isn't that exactly what it does? This doesn't deny anybody's ability to regulate this coarse particulate matter. It just says we're going to give that to the states. And if you don't get it right, we'll come in and make an adverse health finding. We'll do a cost-benefit analysis. And Ms. McCarthy will come in and clean up the mess.
I think that if what you're saying is right, what you're saying is rolling back national standards, health standards that are necessary for public health protection. You're talking about giving those to local communities or states that certainly don't have the scientific or the resource wherewithal to be able to make this happen. So I would say, in essence, you are actually gutting the Clean Air Act.
Yeah. Wow. You just think the states are completely incapable of making sure they can take care of the health. So Kansas, my governor, Governor Brownback, and his Kansas Department of Health and Environment are incapable of protecting the health of their citizens.
Actually,
they don't have the resources. You said they don't have the resources or the scientific knowledge out in flyover country.
I would say that the way in which nuisance dust is defined here, in what you would need to do to regulate it, is potentially beyond the wherewithal of EPA and our scientists at this point in time. And I certainly wouldn't want that burden imposed on states and local communities.
Yeah. Last point. So I think it was Mr. Waxman, and you had a little colloquy about all the horrors that could follow. We could have school buses killing children. Large open pit mining exemptions, and you said that this language might prevent the EPA from regulating those. Yes. This really isn't a question. This is a statement in my observation. You have never let statutory language get in the way of your efforts to regulate things. We've made things clear. We make them explicit, and you run through stop signs. And so here we've got language which doesn't talk about school buses, and yet you and Mr. Waxman say that this is going to allow school buses to do great harm. Do you really believe that this language would preclude you from doing those kinds of regulation for power sources and for school buses? My question is, do you believe that this language would preclude you?
I believe that it very well could.
It very well could.
Yes.
So you would sit with your team and you'd say, I don't think we can do that.
Well, one of the issues is I'm trying to understand what it was intended to do. Was it intended to do that?
Yes, well, you said before it doesn't matter. Right? You said, what does the language do? I think it's very clear what the language does. This language grants the rights to the states to regulate this and keep their folks safe, and then if there are adverse health effects, or if if a cost-benefit analysis is completed, you all can go fix it. So I think it's very clear. We're trying to prevent EPA from doing not what an imaginary congressman said they would do, and not what some silly email chain that was fraudulent sent around, but what your EPA staff said they were considering.
So this bill is actually intended not just to prevent the administrator from ever being able to advance or enhance regulation of farm dust or coarse particles. It is actually intended to roll back 24 years of history in regulating coarse particles that started with the Reagan administration, that continued to the Bush administration, that protects public health today. That's the intent of this bill.
My time is up. It's intended to do precisely what it says it will do. It's intended to stop the EPA from regulating farm dust. And I yield back the balance of my time.
This time I recognize the gentleman from Virginia, Mr. Griffith, for 5 minutes.
Thank you, Mr. Chairman. All right, let's get back into this. We'll pick up right where we left off with Mr. Pompeo, because I'm trying to figure it out, and I don't think that the intent of this bill is to do any of the things that you think its intent is, or that you were trying to imply that Mr. Pompeo was saying it's going to do. I think it's regulating farm dust. That being said, would you all support this bill if you changed on line 15, page 3? Do you have the bill in front of you, ma'am?
I do have it in front of me somewhere. Yes, I have it.
If you changed on line 15, I'm not speaking for the patrons, I'm just asking. On line 15, if you changed the or to an and, wouldn't that resolve all of your semantic problems or all of your language problems?
I'm really not prepared at this time to negotiate the bill. What I will say is that I think that
well, just look at the plain language of the bill. If you put an and there, there's no way anybody on earth could interpret that that would allow mining. Isn't that correct?
I do not know the answer. I can certainly go back and take a look at it.
All right, let's talk about this.
Could I just point out one of the confusing things in the definition?
I'll take back my time, ma'am.
Okay, I'm sorry.
You know, I think most of us over here were offended by the fairy dust comment, and I was concerned about it enough that I got Representative Hurt to bring me his language, and apparently in his district there was a farmer who's already been warned by a state regulator. Now, you indicated you weren't aware of state regulations in Virginia, and I'm happy to share those with you if you would like. And these are the regs, not the underlying law, but the regs in Virginia which talk about fugitive dust. And I guess what I want to know is that based on your earlier testimony, my impression is that you all have indicated to the states that this is the direction that they should go in. Is that not correct? You've indicated to the states that they should be regulating fugitive dust from agricultural sites. Is that not correct?
Not that I am aware of. In fact, when we, even in the coarse particle standard, are monitoring that we base our non-attainment decisions on, it is focused on urban areas. It is both focused on where there is the highest levels of pollution as well as where there's most population exposed. So we do not focus on rural areas as we implement that standard. So
but
I'm not
as
sure
you've indicated, as time goes by, if there's a coarse particulate matter issue, you all are going to go in and regulate that. And I guess one of my concerns is that in regard to another set of regulations, not this one, back when I served in the Virginia legislature on the Virginia Joint Commission on Administrative Rules and Regulations, we had an issue that came up, and it looked like it was Virginia enacting something that we just thought was foolish. And when we pushed on it, they said, well, we've been told by the EPA we have to do this. This was stormwater management. And we said, well, bring them in. And the EPA came in and basically said that, you know, Virginia didn't have any rights even outside the Chesapeake Bay area, and that they were going to force us to do it one way or another. And so I want to know, are we dealing with the same kind of situation with dust? Are you all going to tell the states that they have to do this, or you're all going to come in and tell them how to do it?
This is a national ambient air quality standard. That means that when states are implementing the program. They make their own judgments about what's cost-effective in terms of an implementation strategy for their states, and to the extent that it is lawful, EPA respects that judgment.
Since this bill only, at this time, only has a 1-year time limit or time period in it, and you all have indicated that you're not planning to go forward with any new regulations on agricultural dust, why the opposition? Why don't you join in and support the bill?
Actually, it has two sections. The first one is the one that talks about a 1-year limit, but it's really not limited to coarse particles. It really spills into our ability to regulate fine particles. And Section 3 really attempts to exempt nuisance dust from regulation altogether. And because of how broadly that's defined, it can certainly leak into all areas of the Clean Air Act and prevent us from being able to maintain the kind of health standards we've had for decades and the protections that the American people expect.
But you do understand why people, as Mr. Gardner pointed out and others, why people are a little gun-shy when it comes to the EPA, because we've seen things that don't make sense, and we've had, in fairness, the states have been run roughshod at times by the EPA, and so when we hear some of these things, we don't always necessarily feel comfortable with it, and we have to. We may at some point reach a level of trust, but we're always going to have to verify. Thank you. I yield back my time.
This time, the chair recognizes the gentlelady McMorris Rogers for 5 minutes from Washington State.
Thank you, Mr. Chairman. I appreciate the time, and I appreciate Ms. McCarthy for being here. You know, I too am struggling with the long list of regulations that have been proposed by the EPA administration this year. And at a time when unemployment in this country is at a record high, we continue to face one regulation after another that is making it, if not difficult, impossible for people to comply. I had someone in my office just the other day who said, Kathy, the only way that we can comply with the long list of regulations coming out of EPA is to simply not operate. And that is the fear that our farmers and ranchers face right now. And it seems that the administration is moving forward without the scientific proven health benefits of many of these regulations. Now, 5 years ago, EPA concluded that the current PMT standard was appropriate. And yet, today in many regions, they're still striving to comply with that standard. And that's why it makes us a little perplexed as to why earlier in the year EPA was recommending a stricter standard. And so in eastern Washington, whether we're working in the fields or herding our cattle or driving down a dirt road, dust is going to be kicked up. And that farm dust is a byproduct of American labor, not an air pollutant. So I understand that the administrator has stated that the current standard, which has been in effect since 1987, will be continued. However, I too believe that farmers and ranchers in eastern Washington need more certainty. So I wanted to ask you, what made EPA go from earlier in the year proposing to exempt agriculture and mining to finalizing a standard that does not exempt them?
Actually, that was an action that the Bush administration proposed in 2005 when it was doing its NAAQS review of the PM standard. They did propose to exempt agriculture from regulation on the basis of all the comments that the Bush administration heard. They believed that the science was strongly indicated that it needed to be included within the definition of coarse particles, and they didn't exempt it. That was not this administration. That was the Bush administration. And EPA has yet to propose anything. And if and when we do, the administrator has made it clear what she intends to propose. When that is finalized, if that is challenged, it goes to court. If we lose that challenge, we relook at the NAAQS.
But
you are in no immediate danger of action happening.
But earlier in the year, you were proposing different standards. So what had made you change?
We actually had never changed. We had never proposed anything. What we were proposing on PM10 was to wait for the integrated science assessment. The Clean Air Science Advisory Committee did propose that the administrator consider changing both the standard and form, which really wouldn't have made the standard more stringent, but it would have changed levels of protection in the country. And when the staff looked at that, they believed that the data wasn't certain enough to warrant a recommendation solely to revise, so the staff actually proposed 2 recommendations, one to keep it and one to revise it. When the administrator looked at that, as she indicated in her letter, her assessment was that the science wasn't certain enough to warrant a change in the form and standard, and that she was going to propose retaining that standard. That's how it has worked out, and there's been a lot of misunderstanding, so I apologize. But we have not put out a proposal in this administration relative to PM10 or 2.5.
It feels like the administration continues to flip-flop, though, on where they're going to be on possibly proposing and when they might come. And so I guess I just want to also, it just begs the question, why are you opposing what is a very simple bill to clarify and send a clear signal to our farmers and ranchers that farm dust that is stirred up while they're working in the fields will not be regulated?
I guess I tried to make it clear that that's not what this bill says or does.
Would you be willing to, would you give us your recommendations on how we could write that bill?
We would certainly provide any assistance we can to the committee and that the chairman asks us to provide. I will tell you that it's a little baffling to me because generally I'm here because we're proposing to do something that you disagree with. Now we're proposing to do something that you agree with, and I'm still here.
Well, there was a threat.
There's got to be something we can do. That
we like you, Ms. McCarthy.
It's the fear of what you might do in this example. And
but in one case, the fear is that the administrator will be proposing something and it's sure to happen. In this case, the administrator may be proposing something and you don't think it's going to happen. The administrator has been really clear. She's given this discretion under the law. And it is given, and she will use that discretion wisely, and she's made it clear the direction that we are heading.
And we've heard you say many times today, at this point in time, and we don't know when that might change. I yield back.
Mr. Chairman, on that note, I would, if I could, ask unanimous consent to enter into the record the EPA technical assistance letter requested by myself and the ranking member Waxman.
Without objection, is that it?
This is it.
Thank you so much. Thank you. This time I recognize the gentleman from California, Mr. Bilbray, for 5 minutes.
Thank you very much, Mr. Chairman.
Congressman?
Yes. I was sort of taken back by comments made by the gentleman from Santa Monica that somehow there's no regulation on farming and nobody's proposing regulation on farming, and that the whole concept of regulating farming is a myth. And I'd like you to kind of bring me back up to steam. It's been a while since I've been in the clean air, game. Wasn't there or isn't there ongoing programs to reduce silica emissions in the western San Joaquin Valley?
Yes, there is.
And that is PM10 and 2.5?
Yes, that's true.
Okay, so isn't there also a ongoing program to reduce or eliminate the use of gravel or the use of gravel roads in the Sierra Nevada because of the dust potential with serpentine being used as the gravel?
I am not aware of that. I apologize.
Okay. I think you ask your staff to take a look at that. And then the Owens Valley is a very rural, very isolated area. Last I checked, have they abandoned their concept of particulate management in the Owens Valley?
No, there are many areas in California that are out of attainment of those standards and that work with the agricultural and other communities to try to reduce dust. Yes.
So, for the record, there has been historically intervention in the rural area by regulatory agencies to control and regulate both PM10 and 2.5.
Yes.
Okay, I just want to make that clear because the references was like, nobody's ever done this. We're not talking about this. And the fact is, when somebody out in the West starts talking about this, let me tell you, kind of ask the gentleman from Santa Monica, saying, in our own state, we've had extensive impact on ag and rural area impacts in our clean air management. And I think it's disingenuous to tell the rest of the country that these things haven't happened and won't happen, and don't be worried about it. I think they're a very real situation that we ought to be open and frank about, and not try to deny the fact that there's a real potential, either now or in the future, that farming operations, that rural activities will be severely impacted in their traditional historical manner of operation, because we're looking at addressing both of these particulate issues. Isn't that fair to say?
I'm sorry, I think I sort of...
Is it fair to say that from the history of what we have done in other parts of this country to manage the particular issue, that it is unfair to tell the people in the rest of the rural America, that there is no way they're going to be impacted, no way that their operations may be modified?
Ever. I certainly would never make that claim one way or the other.
Yeah, farming has been curtailed in California in certain areas during certain times of the year. Farming has been impacted. The use of water and the way the water was distributed in a state that is dying for water has been impacted through this management practices on this. And I just think that we just need to clarify that there is this issue of once you justify taking action on the item, you do not say rural, urban has a different game. You do not say farming will be protected in our implementation. Everybody is thrown into the pile. There's no guarantee that traditional agricultural activities will not be severely impacted once you start implementing the programs, right?
You look at all sources of pollution. I will say in terms of agriculture that how the states and local air districts have worked with USDA and the agriculture community has actually been very collaborative. And in the San Joaquin Valley, as far as I know, it's been enormously successful.
Well, I think that if we see the impact and a lot of the concerns over there, and the Owens Valley is the other one that still is a real issue of, do we use our water to feed our cities and our crops, or do we use the water to spray over the Owens Valley to reduce the particular issue? That's the kind of catch-22 that we get into.
One of the reasons why we work with USDA is there are a number of strategies that the farming community can employ. Many of them are supported by USDA.
To interrupt, I want to make it clear. You made a statement that this impacts urban areas, and I think you want to correct. It does not only impact urban areas. Rural areas are impacted severely with the PM10 and 2 and the potential on it. A non-attainment area does not know if it's an urban area or rural area. Non-attainment areas are managed as one proposal.
May I clarify just
yes.
what the point I was trying? I'm sorry.
No, go ahead.
Very quickly. What I was talking about is how you identify non-attainment areas. We monitor non-attainment areas. We don't model them. Our monitoring is focused on areas where you have both high levels as well as high population density. So even in the areas that you're talking about, they are surrounding high population density areas, although the rural areas may come in as part of the non-attainment area.
Excuse me, ma'am, the Central Valley is not an urban area, and the great majority of it's non-attainment. I yield back.
Ms. McCarthy, you raised an interesting issue on these monitors. Would you provide the committee with a list of where monitors are located by state and how that is determined?
Of course.
Thank you. Looks like there are no more questions, Mr. Rush. So, Ms. McCarthy, thanks very much for being with us today. We appreciate your time and look forward to working with you as we move forward. This time I'd like to call up the third panel. On the third panel, we have 7 witnesses. First, Mr. Steve Fogelson, who's a ranch owner of the Black Gold Cattle Company and immediate past president of the National Cattlemen's Beef Association. We have Mr. Kevin Rogers, who is the president of the Arizona Farm Bureau, who's testifying on behalf of the American Farm Bureau. We have Mr. Pete Lean, who's the president of Pete Lean and Sons, Inc., who's testifying on behalf of National Stone, Sand, and Gravel Association. We have Mr. Till von Wachter, who's Ph.D. Associate Professor of Economics in Columbia University. We have Mr. John Walk, who is Senior Attorney and Director of the Clean Air Program at the Natural Resources Defense Council. And we have Gregory Wellenius, who is an Assistant Professor of Community Health at Brown University. So I want to thank all of you for joining us this afternoon to discuss H.R. 1633 and regulation of particulate matter. We look forward to your testimony. Each one of you will be recognized for 5 minutes for your opening statement. And so, Mr. Fogelsong, we will start with you, and you'll be recognized for 5 minutes. And be sure and turn your microphone on.
There we go. Thank you for the technological advice here. Us ranchers sometimes struggle with that. So.
Well, not everyone forgets.
Oh, okay. All right. I'm feeling more comfortable all the time. So, good morning, Chairman Whitfield and Ranking Member Rush and members of the subcommittee. Anybody who knows anything about cattle ranching and feeding knows that many operations are located where wind blows, and that makes dust a part of everyday life. The idea that the EPA may decide to require me and other cattle producers in every part of the country to somehow control that dust gives me cause to lose a lot of sleep at night. The fact is, farmers and ranchers want and need certainty about this issue. While I and ranchers across the U.S. are pleased the EPA has decided not to propose to lower the standard this year, we can't be 100% sure of that outcome of the rulemaking until it's final. In fact, in 1996, EPA proposed to remove the PM10 24-hour standard altogether, only to bring it back in the final rule. And then again in 06, the EPA proposed to exempt ag dust. That exemption also disappeared in the final rule. In addition, even if the EPA retains the current dust standard, the opportunity remains for that agency to tighten it in the future. Unless Congress passes a Farm Dust Regulation Prevention Act, that threat remains. Now, I know that the EPA currently regulates dust. Cattle operations have found it very difficult and expensive to comply. One operation that I know of in Arizona spent $400,000 to comply with that current standard. That's $1,000 a day just to control dust. Most of that is to sprinkle water in those pens. And that's just the current standard. Just think about how much it would cost if EPA were to actually lower that standard in the future. If that happens, the simple fact is that many farms and ranches may be forced out of business. Ranchers have been concerned about that possibility for many years, but most recently the fear surfaced when EPA revealed it was considering making the dust standard essentially twice as stringent as the current standard. NCBA and the Coarse Particulate Matter Coalition commissioned a study on the impact of the possible new dust regulation on rural America. The study determined that vast areas of the Midwest, Southwest, and western parts of the U.S. would be thrown into the brink of non-attainment, if not completely into that non-attainment altogether. It would be one thing if there were good reason to regulate farm dust, but there is not. The regulation of dust under the Clean Air Act is supposed to be based on scientific evidence of adverse health effects. Historically, there have been no such evidence of adverse health effects from dust at ambient levels, but EPA has decided to regulate it anyway. Why? In 06, EPA based its decision on the precautionary principle. That's right, EPA's dust regulation is not based on science but on supposition. Let me explain. Particulate matter, PM, is separated into two distinct sizes and kinds of matter. Fine PM is combustion-driven material in the size range of 2.5 microns and smaller, known as PM 2.5. That's cigarette smoke. Coarse particulate matter, or dust, on the other hand, is bigger particles in the range of 10 microns and smaller down to 2.5 microns. PM10 includes both sizes and kinds of particles. The reason I mention particle size and composition is because, incredibly, the EPA is regulating dust using scientific studies that show adverse health effects that may all be caused by combustion-type fine PM, not dust. The studies EPA reviewed are studies looking at the health effects of PM10 from urban areas that are contaminated with combustion-type fine PM. Any adverse health effects the studies reveal may well be caused by the fine PM part, not the coarse PM. Use of these studies to identify health effects for purposes of establishing a coarse PM dust standard is inappropriate, especially for rural areas where urban contaminants are not a concern. Nevertheless, EPA uses a single standard to regulate dust in urban and rural areas.
The contaminant issue I mentioned is just one of many problems with EPA's PM10 studies. I'm not a scientist or a medical doctor, but I wanted confirmation, so we asked Dr. Jonathan Borek, clinical professor epidemiology and public health at Yale University School of Medicine, to review EPA's health studies. Dr. Borek is a highly respected scientist and, in fact, was one of the founding members of EPA's own Scientific Advisory Committee. He found many problems with the studies on which EPA relies and determined that those studies do not establish risk from a health basis for dust regulation. I've attached his comments to my testimony for the record. In an effort to bring a little common sense back into this process, Cattlemen believe that the best solution is for Congress to pass the Farm Dust Regulation Prevention Act of 2011. Regulatory uncertainty is unnecessary and unproductive. If EPA follows through and does not revise the dust standard, this action would to some degree provide us with certainty, but for no more than 5 years. It provides no relief to producers who are spending over $1,000 a day on dust control measures right now. We need immediate, permanent relief from federal dust regulations on farms, and Cattlemen believe that the best way to achieve that is by passing the Farm Dust Regulation Prevention Act. Thank you, sir.
Thank you, Mr. Fogleson. Mr. Rogers, you're recognized for 5 minutes.
Thank you. Thank you, Mr. Chairman. Members of the subcommittee, my name is Kevin Rogers. I'm a fourth-generation farmer. Farm with my family over 7,000 acres of land in Arizona. We produce cotton, alfalfa, wheat, barley, and corn silage. I am currently the president of the Arizona Farm Bureau, and I also serve on the USDA Air Quality Task Force, which advises the Secretary of Agriculture on federal clean air policies that affect farmers. I'm pleased today to testify on behalf of the American Farm Bureau Federation in support of H.R. 1633, the Farm Dust Regulation Prevention Act. My farm in Arizona lies in one of the worst areas for dust PM10 in the nation. Within the past couple of months, 4 huge naturally occurring dust clouds rose from the desert floor and swept over Phoenix. Also saw some of that happened in Texas as well. It covered Tucson in southern Arizona as well. This is the dust that EPA regulates under the coarse particulate matter with the National Ambient Air Quality Standard. H.R. 1633 provides a reasonable and common sense approach to controlling ambient PM in a way that recognizes the natural occurrence of farm dust while also recognizing the public health mandate the Clean Air Act requires. By excluding the nuisance farm dust from regulation, the bill allows EPA to continue regulating man-made emissions of particulate matter, while at the same time not trying to regulate natural occurrences. The exclusion focuses EPA's attention on things that EPA can control rather than trying to regulate nature. The bill does not roll back any EPA protections afforded under the Clean Air Act. Rather, it reinforces the idea that regulatory decisions should be based on sound science. The record here is clear that scientific data on possible health effects of PM10 or dust is highly uncertain. The bill provides the necessary flexibility for EPA to step in and regulate if the science more conclusively shows the naturally occurring farm dust causes adverse health effects. The bill recognizes the great disparity in the coarse PM10 ambient air quality levels from one part of the country to another, from rural to urban areas, by providing for state and local regulation of rural nuisance dust from farming areas. The bill allows management flexibility to deal with unique local circumstances. We do applaud the recent announcement by Administrator Jackson that EPA will not propose changes to the current PM10 standard. That does not mean that farm dust is not or will not be regulated under the Clean Air Act. For those of us in a coarse PM10 non-attainment area, our activities have already been regulated and will continue to be regulated. The Phoenix area has not been in compliance with the coarse PM10 NAAQS standard for many years. Arizona Farm Bureau participated with the state to develop a coarse PM10 permit to control agricultural PM10 emissions and reduce our agricultural practices that produce PM. The program developed best management practices in 3 different categories. The farmers are required to adopt 1 BMP in each category. The program was recently amended to require 2 BMPs from each category. Now the EPA and the state, because we continue to be in a non-attainment area, are pushing for more restrictions and mandating restrictions against working the fields when winds reach a certain speed. All farms and ranches activities in our non-attainment area are regulated under the Clean Air Act. The program we have is a mandatory program, and all producers must participate. Those who do not participate in our BMP program must obtain an individual air permit similar to those required by utilities and factories. BMPs include practices such as tillage based on soil moisture, not working the fields in windy conditions, modifying equipment to prevent PM generation, speed limits on our unpaved roads, planting windbreaks and permanent cover crops, just to name a few. All these activities place restrictions on farming operations and have economic consequences. I can tell you that if I'm required to park my tractor on windy days or when soil moisture is insufficient, it continues to cost me time and money and lost labor and productivity. Or if I'm required to have my employees drive 15 miles an hour on my farm dirt roads, it will greatly increase the time we must spend on these roads, taking time away from engaging in other more productive activities. Others with similar restrictions suffer similar economic hardships. The fact that Administrator Jackson has determined to retain the current course PM10 standard for the next 5 years is very good news, but it only addresses one part of the dust problem facing rural America. H.R. 1633, by excluding naturally occurring nuisance farm dust from the Clean Air Act, unless the science is more conclusive, warrants it, addresses the other. I thank the committee for your time and look forward to answer questions when it's appropriate.
Thank you, Mr. Rogers. Mr. Lean, you're recognized for 5 minutes.
Chairman Whitfield and members of the subcommittee, thanks. Thank you. Members of the subcommittee, thank you for inviting me to testify on behalf of the National Stone, Sand, and Gravel Association at this hearing on the Farm Dust Regulation Prevention Act, which would prevent the harmful effects of EPA's regulations of nuisance dust. My name is Pete Lean. I'm president of Pete Lean & Sons of South Dakota, which was started in 1944 by my grandfather. Representative Noem is my congresswoman, and I'm pleased to express NSSGA's support of her legislation. My association's members produce more than 90% of the crushed stone and 70% of the sand and gravel consumed annually in the U.S. There are more than 10,000 construction aggregate operations nationwide. Aggregates are the chief ingredients in asphalt, concrete, and used in nearly all residential, commercial, and industrial building construction and in most public works projects, including roads, highways, bridges, dams, airports, water and sewage treatment plants, and tunnels. The aggregates industry has experienced the most severe recession in its history. Production of aggregates has gone from 3 billion metric tons, valued at $21 billion in 2006, to 2 billion metric tons, valued at $17 billion in 2010, a drop of $4 billion. Of particular importance to this hearing is 70% of NSGA members are considered small businesses, and many are located in rural areas. NSSGA members are committed to full compliance with all pertinent environmental laws and regulations and emphasize sustainable practices. I'm proud to say my own family business has reserves and plans for 200 years of operation into the future. We've also won numerous awards, including a letter of commendation from the Bureau of Land Management for reclamation before reclamation was even required by law. We're the winner of the NSSGA's Environmental Steward Award and the only quarry ever to win EPA's Earth Care Award, which was presented by Robert Redford. Like agriculture, resource-based industries such as aggregate producers have limited opportunities to reduce dust. To meet the current standard for dust, or PM10, aggregate facilities are required to have permits with state environmental agencies which seek to control dust by limiting production and requiring control technologies to limit dust on crushers and other equipment and road maintenance. Some dust is generated at an aggregates operation by crushing stone and truck traffic. However, most of it is from uncontrollable sources, such as from roads and wind-blown dust, particularly in our rural areas. There is no practical way to control natural dust sources in the west and southwest and reduce the PM10 ambient air concentration. Nevertheless, EPA continues to promulgate unworkable standards that hurt job growth without any health benefits. For example, in Utah, if EPA would have reduced the standard by as much as a half, 23 of the 29 counties would go into non-attainment, which would result in extreme limits on production and/or facility closures and further threaten much-needed highway funding. One NSGA member has calculated that in order to meet a lowered standard, as contemplated by EPA, a typical facility would have to reduce production by more than 2/3. This would substantially change the business model and lead to plant closure and the loss of 50 jobs or dramatic increase in the price of the product. Given that over 10,000 operations in the U.S. and virtually every congressional district is home to an aggregates operation, this could result in significant job losses. Taken further, a cut in aggregates production would lead to a shortage of stone, concrete, and asphalt for state and federal road building and repair, commercial and residential construction, which in turn would cause an increase in the price of materials for those projects ranging from 80% to 180%, and further suppress employment in the construction industry. Given that infrastructure investment is essential to economic recovery and growth, any change in the PM10 standard would impose an additional burden on the aggregates industry that is unwarranted and would adversely impact aggregate supply and vitally important American jobs. NSSGA appreciates this opportunity to speak on the devastating effects of overregulating nuisance dust on the aggregates industry. Thank you, Mr. Chairman. I'll be glad to respond to questions.
Thank you. And Mr. Blaze, we appreciate your being with us. I failed to state that you're representing the Coarse Particulate Matter Coalition, and you're recognized for 5 minutes.
Thank you. Thank you. Good morning, Chairman Whitfield, Ranking Member Rush, and members of the subcommittee. Thanks for inviting me to testify this morning. My name is Kurt Blaze, and I'm counsel to the Coarse Particulate Matter Coalition. The coalition is an organization of industry groups with an interest in scientifically sound regulation of coarse PM and air. The current members of the coalition are listed in my written testimony. The past 2 reviews of the National Ambient Air Quality Standard for PM10 have focused increasingly on road dust as a potential public health threat. The theory has been that dust by urban roadsides can be, on urban road dust, I should say, that the theory has been that dust by urban roadsides can become contaminated by other materials that render them more toxic. In contrast, dust composed primarily of crustal material have been reported to be harmful only at ambient levels much higher than the current federal standard. Our coalition consistently has supported retention of the current PM10 standard while exploring avenues of relief for natural dust emissions. The current standard limits production and therefore employment by imposing stringent dust emission limits in permits and state plans. Compliance with the current standard is very difficult to maintain at our operations. We have been surprised by recent contentions that the regulation of dust is inconsequential. And there's one extra point I'd like to make here with respect to permits. We've talked a lot this morning about the effect of non-attainment areas, where the monitors are placed. A couple of things there. I mean, even if you're in an unmonitored area now, if the feds change their monitoring criteria, their siting criteria, you can be monitored. If a private party, such as the Sierra Club story that Mr. Hurt told, wants to come in and monitor you, they can do that. And more importantly for our group, really non-attainment and monitoring is almost not an issue, because we have to have permits. And our permits have to show attainment of the standard at the fence line, regardless of the attainment status of the area in concern. It's these permits, even more than the non-attainment or attainment designation, that are limiting our ability to produce right now on the basis of this standard. It's widely recognized that coarse PM concentrations vary widely on a local and a regional basis. A recent study commissioned by our coalition, which was mentioned earlier, sheds further light on this issue. A copy of the report is attached to my testimony. I'd like to emphasize several of the conclusions here. There are great differences in both the quantity and quality of coarse PM emissions throughout the United States. For example, PM10 in the West, Southwest, and Midwest is composed primarily of coarse particulate matter, while PM10 in the East is composed primarily of fine particulate matter. In the West, Southwest, and Midwest, the variations among PM10 within single counties are very high. By contrast, the within-county differences in the East are much smaller. The localized nature of dust impacts leads to a great disparity in the effects of a single federal standard on the different areas of the country. Our study focuses on the impacts of a potential new standard recommended for consideration in EPA's PM policy assessment. The potential new standard would be set somewhere within the range of 65 to 85 micrograms per cubic meter, with a change to the 98% statistical form. The policy assessment concludes that a standard of 85 with the change in the form would be roughly equivalent to the current standard, and I heard the assistant administrator repeat that several times this morning. However, our study concludes that such a standard would be much more stringent than the current standard, particularly in the West, Southwest, and Midwest, as a result of the nature of the PM10 emissions in those areas. Under the potential new standard, localized areas in virtually all of the West, Southwest, and Midwest would be vulnerable to exceedances. This is depicted in a map taken from our report, which is attached to my testimony. In these vulnerable areas, and I don't have it handy, but it covers, oh, there it is. Okay. You can see the extent of the country that it covers there. In these vulnerable areas, farmers, owners of dirt roads, and operators of material storage and handling equipment will have few, if any, reasonable options to reduce emissions. Employment in businesses generating fugitive crustal dust will be impacted negatively. This impact would occur despite the conclusion in the policy assessment that the current federal standard can reasonably be judged to provide sufficient public health protection. Given the choice between the current and potential new federal standards, we have consistently supported retention of the current standard. In that respect, we are encouraged by the Administrator's recent letter indicating that EPA will propose to retain the current standard. However, for the reasons I have discussed, we believe that state and local regulation is a much more efficient and effective means of protecting public health against dust emissions that have a very localized impact. Accordingly, we strongly support H.R. 1633, and we urge the subcommittee to adopt it. I'd be glad to answer any questions.
Thank you, Mr. Blaze. Dr. Van Wachter, you're recognized for 5 minutes.
Thank you, Chairman Whitfield, Ranking Member Rush, and members of the committee. It is a great honor to be with you today. Existing evidence suggests that air regulation provides important benefits in terms of improved air quality, improved health outcomes, and improved housing values. However, it is also widely acknowledged that air regulation carries a potential cost in terms of lower employment and lower productivity in regulated sectors. In my testimony, I will focus on current estimates of these costs, and in particular on the costs for those workers most affected by the regulation, which are workers displaced from their previously stable jobs. So current best estimates of the effect of the Clean Air Act suggest that the economic costs for workers present in the regulated sectors at the time of regulation are non-negligible. So existing research has shown that employment and productivity in regulated sectors declines, at least in the short run. In addition, there are large and persistent wage reductions for workers induced to leave regulated firms, especially those workers who then end up working in a different sector. Whether the costs of air regulation are of the same order of magnitude as the benefits in terms of improved health or housing values is likely to depend on the regulation and the environment in which it takes place. So, for example, the most comprehensive study of the effect of the 1990 Clean Air Act amendments to date suggests that there was a loss in wages over the next 10 years of workers who went into non-attainment of about $9 billion. Now, that's relatively to the estimated benefits of the 1990 Clean Air Act amendments. These losses appear to be temporary. However, it is important to keep in mind that the 1990 Clean Air Act amendments may have represented the best-case scenario. Now, why would that be? Well, this is because the amendments came into force not long before the high-pressure labor market in the mid to late 1990s. And this matters because the cost of regulation in terms of lost wages and employment tends to mostly accrue to workers who are actually displaced due to the regulation. So it's job losers that lose their jobs as a consequence of regulation who bear most of the costs. And job losses, especially job losses for workers who had found a stable job at a good, stable firm, can lead to very long-lasting and large earnings losses. So these earnings losses can last up to 10 to 15 to 20 years. And a job loss is also followed by an extended periods of job instability and earnings instability. And during this period, job losers can experience decline in health. For example, in severe downturns, these health declines can lead to significant reduction in life expectancy over the next 20 or 30 years after a job loss. The consequences of job loss are also felt by workers' children, who can suffer from the consequences even as adults and by their families. And job losses have also been associated with a higher rate of entry into potentially costly public programs such as Social Security disability insurance or early claiming of retirement benefits. The earnings cost of job displacement, and this is important, has been found to be substantially higher in recessions than in booms. So while we know that even displacement in good economic periods can lead to lasting earnings losses, the one exception is the mid to late 1990s, where job losers tend to recover a big chunk of their earnings losses. So workers displaced from their firms as the consequences of the 1990 Clean Air Act amendments were displaced into sort of an ideal case scenario because a few years down the road, a very high-pressure economy pushed up their earnings. To conclude, while many workers affected by air regulations are likely to be sufficiently mobile to find a new job without major losses in employment and earnings, a subset of workers induced to move from their job due to the regulation, be it voluntarily or by layoff, are at risk of experiencing quite large and lasting losses in earnings. Existing research suggests that these earnings losses may be substantially larger in difficult economic environments. Based on these findings, the economic costs of air regulations are likely to depend very much on the economic circumstances in which the regulation is enacted. Hence, a case-by-case assessment of these costs and their dependence on the economic environment, the type of the regulation, and the type of workers affected are important aspects when considering the net gain of air regulation. Now, since I have a few seconds left, let me say the results I quoted from the scientific studies mainly pertain to any reason the county could go into non-attainment. That includes the PM10 standard, but it is not focused on the, say, P3 to PM3 to PM10. But it could be due to coarse particulate matter. It could be just due to fine particulate matters or any of the other 5 criteria. Now, the question you were asking, namely, has coarse particulate matter a differential effect in rural areas that are engaging in agricultural production or where there's a power plant or mining, as opposed to urban areas? But it's a very important question that academics potentially can answer, but it is a very difficult question that requires, as you can imagine, a very large amount of data. So this is sort of a call in my last seconds to provide this detailed amount of information so we can actually answer that important question you're asking.
Thank you, Dr. Van Wachter. Mr. Walk, you're recognized for 5 minutes.
Thank you, Mr. Chairman and members of the subcommittee. My name is John Walk, and I am Clean Air Director for the Natural Resources Defense Council. As the hearing today has shown, H.R. 1633 is premised on a problem that does not exist, that is, non-existent EPA limits on farm dust. However, the devilish details of this poorly drafted bill actually create more real problems than the imaginary problems the bill purports to solve. The bill is sweepingly overbroad, and it creates numerous damaging consequences that appear to be unintended, but that would in fact harm Americans. The result would be increases in harmful soot pollution, not just coarse particulate matter, but deadly fine particulate matter, and across the country, not just in rural America, but urban and metropolitan areas too. The legislation inexplicably weakens, eliminates, or blocks federal Clean Air Act authority over overwhelmingly industrial pollution from power plants, manufacturing facilities, mines, and the like, again, as a result of very overbroad and poor drafting. Before you consider voting for a bill under the misconception that you are just addressing so-called farm dust, I urge your staff to examine closely the testimony by Assistant Administrator McCarthy and my own testimony to see whether you find fault with any of this legal analysis or factual implications of the bill. I will note that none of the other witnesses here today have contradicted those legal interpretations in their written testimony. Finally, I urge your attention to a careful reading of the written testimony of most of the majority witnesses and Representative Noem's opening statement. Each time that testimony complains of existing regulations of farm dust, they are talking about state regulation, not EPA regulation, for example, in Arizona or Illinois. Isn't it paradoxical, then, that this bill does not eliminate state regulation of farm dust or its monitoring? By the same token, some have criticized the temporary relief provided by Administrator Jackson's pledge. Yet this bill provides a 1-year period of relief, whereas Administrator Jackson's pledge provides a 5-year period of relief. Equally paradoxical. H.R. 1633 has been presented under the legislative guise of blocking non-existent and unplanned EPA regulations of farm dust. I invite any witness or member to identify an EPA regulation in the Code of Federal Regulations where EPA imposes limits on farm dust. There are none. Since Mr. Terry, who's not with us now, mentioned NRDC earlier, I invite him or any other member to identify any statutory authority to compel EPA to impose limits on farm dust. There is no such authority for me or any other environmental group to invoke. Finally, I invite any member to identify any job in America that has been eliminated due to EPA limits on farm dust. There is none. If Congress truly wants to address so-called farm dust with a simple bill, all it would take is a single sentence that says EPA shall not limit farm dust if states are doing so already. Yet this legislation does far more and far worse. As Mr. Pompeo correctly reads the bill, it removes Federal Clean Air Act authority over deadly soot pollution from power plants, mines, and the like, if states are doing so already. Mr. Griffith does not read the bill that way, and I think it creates some genuine confusion about what the bill does. But Mr. Griffith does helpfully start to put his finger on things by pointing us to page 3 in line 15 of the bill, where you could at least begin to address some of these problems in overdrafting with the addition of the word "and." However, I would like to note that this would still allow the exemption of pollution if an activity typically occurs in a rural area. As Mr. Waxman said, 70% of power plants do so. I don't think that's what the committee intends. By the same token, it would allow the exemption of pollution if it's windblown. I hope we can agree that all pollution is windblown, and we don't want to eliminate federal regulation by virtue of that fact. Section 3 really is the most problematic feature of the bill. I think my written testimony and Assistant Administrator McCarthy's testimony covers that, so I'm not going to repeat that now. But I do have to say that this bill does produce what appear to be unintended consequences that I think could be corrected, but not based upon the existing structure of the bill. I noticed that elsewhere in the House this week, the Judiciary Committee is considering the REINS Act, which purports to address and rein in excessive delegation of congressional authority to federal agencies. And yet, again, paradoxically, H.R. 1633 engages in excessive delegation of sweeping and vague authorities to deregulate industrial pollution across America. I don't think that's what the bill intends to do, and I would urge you not to pass H.R. 1633 in its present form. Thank you.
Thank you. Dr. Wellenius, you're recognized for 5 minutes.
Thank you. Thank you, Mr. Chairman. Members of the committee, thank you for the opportunity to testify today. My name is Dr. Gregory Wellenius. I'm Assistant Professor of Epidemiology at Brown University. I earned my doctorate in environmental health and epidemiology from the Harvard School of Public Health and previously served on the faculty at Harvard Medical School. I have been conducting research on the health effects of air pollution for more than 10 years, have authored or co-authored more than a dozen original studies in this area, and contributed as an author for the EPA's 2009 Integrated Science Assessment for Particulate Matter. My research has focused on the effects of ambient air pollutants on cardiovascular disease, and it is my pleasure to provide testimony in this area today. There is a broad consensus in the scientific and medical communities that ambient particles are harmful to human health. For example, after reviewing the scientific evidence, the American Heart Association recently stated that exposure to fine particles, or PM2.5, is, quote, a modifiable factor that contributes to cardiovascular morbidity and mortality, end quote. The external panel of independent scientists that make up the Clean Air Scientific Advisory Committee, or CASAC, and EPA scientists concluded that a causal relationship exists between ambient air particles and, ambient fine particles and both mortality and cardiovascular effects, and a likely causal relationship exists between ambient fine particles and respiratory effects. This conclusion has been endorsed by a number of scientific organizations, including the World Health Organization, the National Research Council, the American Medical Association, the American Lung Association, and the American Thoracic Society, to name a few. As has been pointed out, the coarse and fine fractions of particulate matter differ in their size, sources, and composition. In my written testimony, I provide further details regarding the well-established health effects of ambient fine particles. While fewer studies have looked specifically at the health effects of coarse particles, the existing evidence suggests that these particles can also be harmful to people's health. In the 2009 Integrated Science Assessment for Particulate Matter, CASAC and EPA scientists concluded that the available evidence is suggestive for a causal relationship between coarse particles and mortality, cardiovascular effects, and respiratory effects. The available science indeed supports an association between coarse particles and cardiovascular hospital admissions. For example, a recent study in 112 U.S. cities found that coarse particles were linked with higher risk of premature death from all causes, stroke, and respiratory causes, even after accounting for levels of fine particles. Similarly, a study of 15 counties in California found that coarse particles were associated with all-cause cardiovascular deaths, even after adjusting for levels of fine particles. Taken together, the existing evidence suggests that exposure to higher levels of coarse particles may increase the risk of death, cardiovascular hospitalization, and respiratory effects. Now, most epidemiologic studies on coarse particles have been conducted in urban settings. However, agricultural dust can also be harmful to people. Field workers exposed to mineral dust from agricultural sources experience more acute and chronic bronchitis, chronic obstructive airway disease, and interstitial lung disease. Agricultural workers exposed to organic dust have been found to have a higher risk of allergic reactions, asthma, hypersensitivity pneumonitis, and organic dust toxic syndrome. A study examining the lungs of California farm workers found that their bronchioles had accumulation of dust particles and thickening and inflammation in the respiratory tissues. Sandstorms and other dust events typically increase the concentration of coarse particles much more than fine particles. Studying these events provides information on the potential health effects of coarse particles of non-urban origin. For example, Asian dust storms in Taipei, Taiwan have been associated with increased rates of hospital visits for ischemic heart disease, such as heart attacks. Other studies have linked dust events in Spain and Cyprus with increased risk of hospitalization or death. These studies add to the evidence of health effects of coarse particles and highlight that even coarse particles from non-urban environments can have important health effects. In conclusion, Congress built into the Clean Air Act an orderly process for the regular review of the scientific evidence on health effects of air pollution. This process includes multiple rounds of scientific peer review, including by CASAC and other scientists and the public. I strongly urge you to preserve the authority of the EPA to periodically review the available scientific evidence and, when appropriate, update the air quality standards, including for PM10 and coarse particles. This process is essential if we are to adequately protect the public's health. I thank you for your time and would be happy to answer any questions.
Thank you very much for your testimony. I'll recognize myself for 5 minutes. Questions? Mr. Walk, you heard me in the very beginning talk about this concern about the lawsuits being filed and so forth. And has the Natural Resources Defense Council ever sued EPA over the Clean Air Act?
Yes, sir, Mr. Chairman, we have.
Do you know how many times?
You probably do if you've researched the question. I have not there, sir.
Well, I haven't either, but
no, I don't know.
And have you all been reimbursed for legal fees?
When we win,
yeah. Would you provide us with the number of times that you all have filed suits against the EPA and the number of the dollar value of the reimbursement for the legal fees?
I will do so to the best of my ability. NRDC was formed in 1970 or 71. So
well, let's just say within the last 10 years.
Okay,
Mr. Chairman.
Yeah.
It'd also be good to find out what was their compensation out of the judgment fund that paid their attorney fees.
Yeah. Yeah, the amount of the legal fee reimbursed, and it comes out of the judgment fund, though, doesn't it? Yeah, or the agency funds. Yeah.
Sure. I mean, Mr. Chairman, I would just say that the law only provides our ability to go to court and regain fees when the government's breaking the law.
No, I understand.
And so we,
yeah,
you know,
Mr. Chairman, I just think we should have that. For whatever reason, we want those dollar amounts.
Yeah,
sure.
Yeah, we won't get into a discussion about
Mr. Chairman,
yes.
I would also like, if I might, ask the gentleman if he would include what his one loss ratio is, the number of times he sued, number of times he lost, and the number of times he won against the EPA.
You want to know how many he won and how many he lost?
Right.
Yeah. He wants to know how many he won and how many he lost. Okay. Anyway, so if you would, the number of lawsuits, say, in the last 10 years, the amount of money that you've been reimbursed in legal fees when you won, and how many cases you consider you won and how many you consider you lost.
Okay, it might take some time to do that, sir, so I will just ask your indulgence.
Yes, sir. Thank you so much.
Can we give him 5 years?
Well, you and I may not be here in 5 years. Thank you so much. Mr. Fogelsong, you represent the National Cattlemen's Association, is that correct?
The National Cattlemen's Beef Association, yes.
Beef Association.
Don't worry, I do it all the time, sorry.
And are there cattle producers that are struggling with meeting the current coarse particulate matter standard?
You know, in particular, there are some of those, you know, in the Southwest. Arizona's a good example of that, you know, where they got feed yards. And it's
the expense that they incur to try to comply is just enough to break them.
Yeah.
They just can't kind of keep it going. But I think, and that's what sticks in your mind, but I understand that it can happen any place in the country. We had a map up there earlier that shows those places that are at risk, but I'm from Illinois, and we get 40 inches of rainfall, but I will guarantee you that last week I was in that position because it hasn't rained there in 2 months, and the wind was blowing, and we're all doing work.
Yeah.
So I think that's one of the things that's a challenge. The same thing, our outfit in Georgia was the same thing. We had the worst drought there in 100 years this spring. Driving up and down our country dirt roads, every one of them was out of compliance. So
Right.
all across the country run into that. Yes,
and there was great concern about the strengthening of this emission standard on coarse particulate matter, because that would have changed the standard around the country, and then there would have been more areas in non-attainment, and then there would be more enforcement mechanisms. And Mr. Rogers, you've experienced that personally, it sounds like. Is that correct?
Yes, sir, that's correct. We farm in Maricopa County in a non-attainment area.
And so what enforcement mechanisms must you comply with as a result of being in a non-attainment area in this coarse particulate matter issue?
Agriculture in Maricopa County was deemed through modeling to be about 3% of the problem of the Maricopa County area, which is probably a 75 square mile county. It's a very large county. We only have 15 counties in Arizona. And so we were deemed to be 3%. You come to the table with EPA being the 500-pound gorilla, because what they hold over the state's head is the federal tax dollars, the highway dollars coming back to the state. So there's motivation through your local government to come to the table and participate. And so that's what we've done. We've had to do. We've had to come to the table and design a program with EPA looking over our shoulder to make sure that at every step of the way they agree with what you're doing to put together your SIP problem.
And could you just quickly go through a couple
Sure.
of things?
We developed a best management practice program that is mandatory. Farmers do get to choose between practices under 3 different categories: tillage and harvesting, cropland, non-cropland. So every part of my operation I have to be doing something. And so it could include watering roads, it could include parking your tractors during high wind events where the wind gets to 26 miles an hour, speed limits on your farm roads where you have to regulate your own roads that you're in control of, waiting for there's moisture in the soil before you do tillage, waiting for rain to bring that moisture, or if you choose to irrigate, that's your option as well. But there's probably 40 best management practices that we had to come up with to help agriculture come to the table, to keep EPA happy and to keep our state happy, because at 3% of the problem, they determined that we needed to participate. We do have a county just south of Phoenix in Pinal County, which has been recently designated as non-attainment. That's where the livestock operation is that we talked about before. That particular livestock operation has taken upon themselves to figure out what they can do to get into attainment. It takes 4 gallons of water per day per cow to meet the standard. And it's going to be very costly for them to do that.
40 gallons per cow per day?
4 gallons.
4
gallons, but it's a large operation, so it's going to cost a lot of money. And with 4 gallons per day, they were able to bring that under control. And so they're going to, as we move forward with bringing livestock into our program, they're actually working with EPA in the state, and that'll probably be a mandatory number.
Okay. Mr. Rush, you're recognized for 5 minutes.
In your written testimony, you take issue with using the phrase farm dust, as H.R. 1633 is named, and say that this bill is really an attempt to force EPA to ignore harmful pollution emitted overwhelmingly by industrial polluters like coal-burning power plants, accelerators, chemical plants, and oil refineries, along with diesel vehicles. Can you explain why you view this bill as a cover for abolishing a review of health standards for industrial pollution?
Certainly, Mr. Rush. It's notable that the word farm dust doesn't actually appear in the bill other than its title. The operative legal term of the bill in its most harmful form is in Section 3 in the definition of nuisance dust. And it's simple, so I'll just tell you the highlights. Nuisance dust means particulate matter from activities typically conducted in rural areas or windblown dust. Now, I just selected out some of those from a string. You know, as I showed in my testimony, activities typically conducted in rural areas include power plants and incinerators and manufacturing facilities and diesel vehicles. And, you know, by this very short, crisp, and overbroad definition, all of those activities would be defined as particulate matter that could not be regulated by the federal government if the states are doing so, and the states are doing so. So this bill would deregulate from, you know, federal Clean Air Act authority those activities. That has sweeping implications that certainly aren't suggested by the farm dust title and don't even appear to be intended by some of the members from their statements here this morning.
Thank you very much. Mr. Chairman, earlier there was a line of questioning that I thought was quite interesting, and it covered areas of the legal fees and the amount of money recouped through legal representation. And in fairness and in full disclosure, I want to ask the same question of all the members of the panel. Please, if you will, provide the lawsuits brought against the EPA by the American Farm Bureau Federation, the National Stone, Sand, and Gravel Association, and the National Cattlemen's Beef Association, and the fees that was obtained as a result of those legal actions. Would provide the committee. And also, I understand that Mr. Blaze is being paid by the Coarse Particulate Matter Coalition, and we would like to get, would you provide to the committee the full amount that you're being paid to represent them? Mr. Chairman, I think that is for full disclosure. And would you please provide those amounts for the record?
Without objection, so ordered.
All right.
Point of clarification, do you want to know also what we spent?
No, I want to know what you were, the fees that you were provided.
Okay.
For, and I think that would cover the same territory that was, and the request that was asked of Mr. Walkie. We just want to make sure that there's full disclosure and there's fair disclosure in terms of fees and that organizations are able to, or remunerations from the EPA in the matter of lawsuits.
Will the gentleman yield?
I don't know if I got any time. Of course.
Well, I would be interested in what they spent. If we're going to get the compile that information, let's be complete.
Well,
I would be interested in what you spent. So
right.
I will add that to Mr. Rush's request.
And so we will also add that to Mr. Walker's request. What is the amount that your organization spent, and the amount that you spent in terms of court action?
Oh, on the litigation?
Yeah, on the litigation.
Okay.
Everybody follow that? Without objection, so ordered.
Everybody, right. You're back.
Gentleman's time expired. And the chair recognizes the senator from Illinois, Mr. Shimkus.
Thank you. It's great to have this panel. Can anyone define for me what "at this time" means? Mr. Fogelsong, you know what "at this time" means? At this time. Okay, I'm making my point. The point is, when the assistant administrator was here, in her testimony, she said, I read the letter. Excuse me. I read the letter, and of course, the Administrator Jackson said, "I am prepared to propose a retention with no revision of the current PM10 standard form when it's sent to OMB for interagency review." And her response was, "We're going to abide by this at this time." At this time means today, right? And there could be tomorrow would not be at this time. Tomorrow would be tomorrow. Isn't that for Mr. Fogelsong, Mr. Rogers, Mr. Lean, isn't that part of the risk, the uncertainty that you're dealing with?
That's completely part of the risk. And as the monitoring network is developed across this country, where there may not be that intense monitoring network today, as those monitors are enhanced, that's where at this time comes into play. There may be a speed limit across this country, but if there's not an officer there to pull you over, he doesn't know if you're going 5 over or not. It's a monitoring issue.
And if you could pull up Mr. Blaze's staff over, I don't think she's paying it. Could you pull up Mr. Blaze's map on the proposal? Half of the country under a proposed, that's additional risk to agricultural America. Everybody knows in this country jobs are impacted, and one of the major impacts is risk, is uncertainty. That is why we're doing this today, to at least give the agricultural some certainty. Now, Mr. Lean, you're from the sand and gravel. 2 weeks ago I read, you know the only sector in this country that created jobs over the last quarter? You should.
I would say that
it was the mining industry. The mining industry was the only sector in this country that created jobs. And just yesterday, Caterpillar gave its quarterly report. And Caterpillar did well. You know what Caterpillar sells? Mining equipment. There is a debate on rules and regs and a cost of doing business based upon uncertainty and job creation. And all this is about providing certainty. I would agree with Mr. Hurt that we can. We're legislators. We sure can legislate when it has harm to job creation in parts of the country. If she would also pull up my harvester cutting beans, those are coarse particulates. They're probably bigger than the PM10. Does anyone know how far those coarse particulates travel? I don't know.
It depends on if there's wind activity or not, but those coarse particulates that you can see normally will settle back down within several hundred feet.
And that's all part of the rural debate, because there's not people around. In rural America, it's not like a city. It's not a metropolitan area. In my new congressional district, parts of 33 counties, I think my biggest community is going to have 33,000 people in it. It's 1/3 of the state of Illinois. So if we're farming in my district, which we do, and we're cutting beans, those coarse particulates are going to fall to the ground way before they reach any exposure, especially with the air-conditioned cabs these guys have now. So even the person on the harvester is not going to be affected. Let me go to Mr. Walk real quick. Administrator Jackson, in essence, said that the PM10 standard really by this protects human health. The standard today, that's why she's not going to submit to 1B. Is that the NRDC's position?
We're prepared to accept that when she proposes the rulemaking to not change the standard if it's supported by the evidence.
So your testimony is that you will not sue if this continues to be promulgated and the administration keeps this as a standard?
Mr. Shimkus, that's the first time that word has come out, and it was your mouth, not mine.
At this time?
We are at this time today. Now, I am not going to discuss litigation before I see.
So you might bring this,
Mr. Shimkus, if you want, if this is going to be a semantic.
No, I'm just asking a question.
Let's talk about speculation
reclaiming my
and
time,
imaginary
Mr. Chairman.
problems. But
reclaiming my time.
There has not been
Mr.
a decision to
you're
evaluate.
very cavalier with the lives of rural America and agricultural America, saying, in disrespect to the testimony received, that the PM10 standard affects their jobs and their economy. So I'm just addressing the point that the NRDC is not on record as saying whether they will or not.
If I may, Mr. Shimkus, this bill removes Federal Clean Air Act authority over 80% of America. 80% of America has Federal Clean Air Act authority removed.
Gentleman yields back his time. At this time, I recognize that.
Wait, Mr. Chairman. No.
For what?
Mr. Chairman.
For what purpose is Mr.
Regular order, Mr. Chairman.
Regular order.
All right, regular order. Mr. Shimkus asked the gentleman a question.
I did not, I did not, my colleague.
Will the clerk, will the recorder please read the last question that Mr. Shimkus asked?
No, can we just stipulate that Mr. Shimkus did ask a question, time expired, and then he decided he didn't want to
he didn't, but and he cut him off in the middle of
the
answer.
That's not true.
He cut him off in the middle of the answer. Would you please give the witness the courtesy of answering the question? We do that as a formality in this subcommittee.
Mr. Chairman, if you'll yield to me, I will yield the witness 30 seconds to respond.
Well, Dr. Burgess, I'm going to recognize you for 5 minutes for questions, and you can do what you want to with it.
Well, and the committee has a long history of treating its witnesses well. I'll recognize the gentleman for for 30 seconds to respond.
For 5 minutes.
Dr. Burgess, thank you for your professional courtesy. I'll only take 30 seconds of your 5 minutes. The point I wanted to make in responding to Mr. Shimkus was that in contrast to imaginary problems or imaginary lawsuits that no one has any intention of bringing, this bill, if adopted into law, would remove Federal Clean Air Act authority over 80% of America, which is defined as rural by any number of government metrics. That has nothing to do with farm dust, but it does have to do with deregulating industrial pollution from power plants that causes premature deaths and heart attacks, and that's the only thing I was trying to say. Thank
okay,
you,
reclaiming my time. Can we go back to that map that had half the country in blue? Can we recall that slide? You know, I listened to the testimony of Dr. Wilnius, and in your written testimony, you talk about most existing epidemiologic studies on coarse particles have been conducted in urban settings. Most of the urban settings, actually, though, are removed from that map that is covered by the footprint of the coloration. Is that correct?
So we do the studies where we have monitor data existing primarily, and the EPA cites those monitors. From the research side, we don't have a say as to where those monitors are cited. So there are parts of the country that
but the real hot spots for cardiovascular disease, lung disease, interstitial lung disease, industrial pneumoconiosis, if you were to color those in on the maps, they likely would be, for the most part, outside the blue footprint. Is that not correct?
So there's several areas that are in blue there that do have high air pollution. There's parts of Texas, parts of Arizona, parts of Southern California that do have high air pollution.
Texas is a huge state.
Exactly.
Houston has a problem. It's minuscule. It can be ignored most of the time, as we in the Dallas-Fort Worth area know well. But I just would make the point, is there a cost-benefit analysis you have done? I mean, you want to implement something on vast swaths of relatively low-density population. Have you done a cost-benefit analysis on how this would affect people's livelihoods and the status of people overall, the overall health of people? And how can we be sure, sitting here on this committee, that you're not double counting some of these people that are saved in your studies? How can we be sure you're not double counting those individuals?
Right. So
those are the people that might have been saved anyway by the effects of the Clean Air Act, where this additional regulation would have only minuscule positive or negative effect.
Mm-hmm. Yeah, so thank you. You asked me first the question of have I done a cost-benefit analysis, and the response is I have not. The scientific community is large, and there's those of us that deal with the health effects of air pollution, doing the health side, and there are people in the cost-benefit business that certainly take those health effects that we estimate and also incorporate the costs of regulation and the costs of the lives averted or the hospitalizations averted. I am not specifically in that area, so no, I have not conducted that cost-benefit analysis.
Okay, so we don't know is the answer to that question. Now, Administrator McCarthy had a rather large compendium of documents next to her as she testified, and this is described as the Integrated Science Assessment for Particulate Matter. Are you familiar with this document?
Yes, I am.
My read of at least a portion of this is that there is insufficient evidence to determine that coarse particulate matter causes health effects. That's written on page 219, third heading, maybe sixth line from the end of the page. To date, a sufficient amount of evidence does not exist in order to draw conclusions regarding the health effects and outcomes associated with long-term exposure to PM10. Is that accurate?
That's accurate. For long-term effects of coarse particles, there is next to no evidence in support of long-term health effects.
Well, and certainly we'll stipulate your credentials and the credentials of everyone at the witness table today. But one of the tasks that we face is how do you approach regulation in a way that does not further cripple the economy, allows witnesses at the other end of the table to continue their livelihoods and to support their employees and their families. Forgive me, it looks like we're going on some pretty thin evidence here with some fairly sweeping regulations, and I guess that is overall what the concern here is of the committee today, and I think the reason that Representative Noem brought the legislation forward. I thank the gentleman for his indulgence. I'll yield back the balance of my time.
Thank you, Dr. Burt.
Mr. Chairman?
Yes.
Thank you. So I agree you do have an enviable task, and one that I am happy you're doing rather than me, in terms of balancing the public health benefit versus how to impose those regulations in a sensible manner. You focused on the long-term effects of long-term exposure to coarse particulate matter. There is evidence on the short-term exposure that is associated with increased hospitalizations, increased premature deaths. We need more research for sure, but the current evidence, as the integrated science assessment concludes, is suggestive of causal association. Thank you.
Mr. Olson, you're recognized for 5 minutes.
I thank the chair. More importantly, I thank the witnesses for your time and expertise today. And I'm from Southeast Texas, Sugar Land, Texas. There is no equal. There you go, a little joke. But as you guys know, Texas, all of Texas, has suffered an historic drought, excessive heat, over 100 degrees for almost the entire month of August in Houston, which is unprecedented, and wildfires all across our state. And ranchers and farmers have been disproportionately hit by these disasters. And the theme of this series of hearings that this subcommittee and the full committee has had is about the uncertainty created by the administration's regulatory agenda. I want to talk a little bit about that. I mean, there's been some testimony in the prior panel and even on this panel about uncertainty and the fact that, EPA's promise not to revise the standards for 5 years provides more certainty than a law, H.R. 1633, would provide. And I'm curious if some of the panelists honestly believe that an executive branch agency action provides more certainty than a law passed under our Constitution by Congress. And I'm just asking for a simple yes or no answer. Mr. Fogelsong?
I don't believe it's exactly how I would put that out. We look to you all because we vote you into Congress. We expect you to look out for us.
Sounds like Congress over executive branch agencies.
Absolutely.
Yes, sir.
I would agree.
Yes, sir. Mr. Lean?
I would agree.
Thank you, sir.
I would agree.
Uncertain. If your question is whether regulation reduces uncertainty, that's true. Whether uncertainty has an impact on economic activity, that's from a scientific point of view an open question.
My question is, though, what provides more uncertainty? Executive branch agency regulation or regulations by laws passed by Congress? I mean, which one provides more certainty? What's more difficult process, going through the Constitution or going through the executive branch? I think the answer is the Constitution. Wouldn't you agree? Yes or no?
think you're better qualified than me to answer that question.
Well, you're an American. You've got opinion. Mr. Walke.
You know, as a matter of law, they're equally lawful. If the legislative period of relief is short, like this one, and the administrative period is longer, then it's the longer period.
Okay, and Dr. Wellnius. Sorry about that, sir.
No problem. I have no comment.
No comment whatsoever. Okay, my final round of questions is for Mr. Blais. And Mr. Blais, can you give a brief history of the last round of the PM revision and this one? And specifically, is it possible for us to be in the exact same position in 5 years with farmers, ranchers, and other rural businesses if the EPA chooses to lower the standard on dust?
Oh, yes, absolutely. That is what happened the last time. It's a kind of a complicated thing, and I won't go into all the details, but, you know, there's been a debate over, you know, the current standard for PM10 includes PM 2.5. It includes fine and coarse. So there's been a debate over whether the fine should just be kicked out, and the coarse PM standard should only be the top 2.5 to 10. I think my personal view is that's probably what's going to happen in the next review. But in the last review, what happened was EPA took a stab at doing just that and regulating true coarse PM. The problem with that was the concentration limit was way lower than most of us thought we could meet. Therefore, there was an exemption proposed for agriculture and mining activities. In the end, EPA threw up its hands and said, we don't know what the numbers should be, we don't know what the exemption should be, so we're going to retain the current standard. But yes, the proposal, if the point is the final rule can look quite different from the proposal, the last review proves that.
One final question about the rulemaking, and I've introduced a bill, H.R. 1341, which is called the Establishing Public Accountability Act. It's very simple. It just requires EPA to do some study of the impact of jobs on regulations and rulemaking, their proposed changes, and it requires them to do this before the public comment period, so the public will have the opportunity to review what EPA is proposing. And so I just want to ask all 6 of you again, I got it right, 7 actually, if I count them all, just yes or no, do you think that bill would be something you would support? Start at the end there. Mr. Fogelsong.
Sure.
Yes.
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 That was a bit quick for me, but it seems that if EPA is supposed to look at both the costs and benefits of their regulation, then that seems a good idea.
Put you down as yes. Mr. Walke.
Is that the Regulatory Accountability Act, Congressman?
Establishing Public Accountability, H.R. 1341. I can get you a copy of it, but it basically is very simple. Just the public has the right to know, you know, whether or not this regulation, this new rulemaking, is what the impact is going to be on American jobs. Either it's going to create jobs or kill jobs. And that's something, I mean, again, that's what we need to address here. I think that's the biggest challenge our country's facing is the lack of jobs in this recession that we're creating.
Well, I'd love to read the bill before answering that question, if I might.
We'll hook you up.
Thanks,
And
sir.
finally, Dr. Wellnius.
Again, I'm here to comment on the science and the health effects, not on the policy.
Thank you, sir. That's it. Yield back my time.
Thank you, Mr. Olson. Mr. Pompeo, you're recognized for 5 minutes.
Great. Thank you, Mr. Chairman. Mr. Blais, Mr. Walke said that no one had contradicted sort of the legal statements that Ms. McCarthy set out in your counsel, so I thought maybe you could help me. He also made the statement that 80% of the federal regulatory would be stripped away by this bill. Care to comment on what you think this legislation would do with respect to the scope of the EPA's ability to regulate?
Yeah, I think it's a carve out for crustal coarse particulate matter, and nothing else is involved. I mean, power plants, tailpipe emissions, it's all fine PM. I don't believe these changes are necessary. If people think changes are necessary to this legislation to exclude fine PM, my group would probably support that. But as I read it right now, I think it's confined to coarse crustal emissions, which is what is supported by the science and as it should be.
So your legal analysis is very different from Mr. Markey's comments, Ms. McCarthy's statements, and Mr. Walke's testimony.
Very different. Yes, sir.
So I got it. Power plants not excluded. School bus tailpipe emissions, no impact. Soot and other pollutant powers. This notion of because they're windblown, they'll all get caught up in this, and we won't be able to regulate them should this bill become law. Nonsense.
No, I don't believe it covers those at all.
Okay, great. I'll give back the balance of my time.
Thank you, Mr. Pompeo. Mr. Griffith, you're recognized for 5 minutes.
Dr. Von Wachter, is that the proper way to say it?
Perfect.
Thanks. Your testimony mentioned that those who lose their job can experience health problems that can lead to significant reductions in life expectancy. I've been very concerned about a number of EPA regulations related to similar things, like what happens when you raise the cost of electricity and people in my district can't afford to heat their homes. And so I would just ask you, in regard to the job loss and then significant reductions in life expectancy, can you explain that and tell me what you mean by that, and can it actually shorten a worker's life?
Absolutely. I'll be happy to clarify. So what we have done, we have looked at workers displaced in large downsizing in Pennsylvania in the early 1980s. And these were workers at relatively large, stable firms and do those stable jobs. And they had very long-lasting earnings losses. And over the next 20 years, they also had increases in mortality rates. And those who had the larger earnings losses had the higher increases in mortality rates. And if you add those 20 years up and assumes that the mortality effect lasts until the end of our lives, which seems to be a fine assumption because the effects are very stable, then you get to the 1 to 1.5 year losses in life expectancy. So this one-time shock to what seems to be a shock to earnings, but also to lifestyles more generally, can have these long-term effects. Now, Pennsylvania in the early 1980s is a very hard-hit state with the reduction in steel and mining at that time. So I would characterize that as a worst-case scenario.
And So what you're saying is if we're going to study the health impacts of regulations, we also look at the unintended consequences if it does have a downturn in jobs, that could actually negatively impact the health of workers and of a particular community.
Oh, absolutely. So regulation affecting certain businesses strongly could lead to job displacement that have been shown to lead to job displacement. And if these displacements take place in a sort of very depressed economic environment, they could have very large costs for the affected workers in terms of earnings, but also other outcomes.
Mr. Blaze, did you want to respond?
Yeah, I have a brief response to that. Our coalition has spent some time looking at what's a great developing body of scientific literature that suggests that unemployment itself causes adverse health effects, which I don't think takes an epidemiology study to show for most of us. But however, we have pressed that point with the agency, but have been told repeatedly that they have no legal authority to consider that aspect. So we will be making the point in our comments on the upcoming proposal and in other forums. But as of now, EPA is telling us, the health effects of unemployment cannot be considered in this equation.
And I know you don't have any study on it, but I think that plays into my fear that when we raise the cost of goods and services, particularly goods, again, I get back to heating, but also we're talking about these dust things that could raise the cost of food products. That makes it particularly hard on the working poor or the unemployed, and that too would, by common sense, seem to have a health impact. Wouldn't you agree?
Yes, I would.
Yeah. All right. I thank you very much for being here and all of your testimony, and I appreciate Mr. Walke noting that there may be a way to fix that concern of his, although based on the definitions, I recognize that it may not need fixing. That being said, Mr. Chairman, I yield back my time.
Gentleman yields back. Mr. Rush, you seek recognition.
Mr. Von Waske and Mr. Blaze, you just kind of touched on something I'm interested in. You said unemployment have a health consequence for the unemployed. Is that correct?
So yes. what we can establish in sort of scientific is that the job loss has an effect on health.
On health.
Establishing that unemployment has an effect is very difficult because once you lose your job, being unemployed is partly a choice of the worker. So it's not clear what is cause and effect at that point. But job losses have been shown to have effect on health in the short and long run. And it's possible. Did your study include the chronically unemployed and the underemployed? So, as I said, it's difficult to establish those effects for those who are chronically unemployed or currently underemployed, just from a statistical point of view. We don't know what the right comparison group is. Now, presumably, from what we know, these people are unlikely to do better, but one has to be very careful because unemployment is itself an outcome. For example, a sick worker might become unemployed, and you don't want to conclude that unemployment makes you sick. But if you're displaced from a large downsizing, presumably you were just a good worker, and that being displaced from a downsizing doesn't make you sick. So that's a statement about causality that's easier to back up.
Okay. Are you back, Mr. Chairman?
Thank you, Mr. Rush, and thank all of you for your time and for giving us your entire testimony as well as your oral testimony. We look forward to working with all of you as we move forward, and thank you very much for attending. And with that, the hearing is concluded, and the record will remain open for 10 days for any additional materials. Thank you.